for the customs, Lordship. In 56 today morning, I found out some documents which needs to be bring on record, Lordship. Therefore, Lordship, it may come next Friday, Lordship.
Tomorrow or next Friday?
Next Friday, Lordship. Next Friday, I'll because the
Madam, you are for whom?
I'm not.
Some other matter.
Lordship, I have informed SC Kyle.
Okay.
that it comes.
Madam, he wants on Friday next. Okay. So you like to file additional affidavit?
Additional affidavit bringing on the documents.
Sri BP Bora, learned counsel for the petitioner, has submitted that certain documents are required to be brought on record, and he accordingly prays for some time to file additional affidavit. Full stop. Matter accordingly stands adjourned to be listed on Friday next, huh? Date? Oh, Friday next is a holiday.
And
Next Friday, 4th is a holiday. Can we have it 7th?
Yes,
Monday?
Monday.
On 7th.
Monday.
7th. By which time additional affidavit may be filed?
Yes. Deeply.
7th September.
I'm making item number 3 to 37, already given you a lot.
Yes.
And I have taken consent of the.
You have a difficulty.
Yes.
When do you want?
I'm going to file affidavit.
You'll be filing affidavit. Okay.
Yes.
Ms. K. Fukar, learned CGC. You'll file one consolidated or what?
And no, you're actually already 2 cases I have filed. The department said 14 more cases. I
Okay.
need to file.
Ms. K. Fukar, learned CGC, has informed that in this series of matters, affidavit in opposition has been filed in 2 writ petitions.
Yes.
Full stop. She, however, prays for time to file certain more affidavits in other cases. Full stop. Also heard your name?
B. Sharma, Lordship.
B. Sharma, learned counsel for the petitioner. Para. Matters accordingly stand adjourned to be listed when?
After weeks,
Uh,
weeks or 3 weeks.
we'll have it on 18th September.
Yes, sir.
18th September. This series, huh? 18th September.
Okay.
Obliged, Lordship.
Okay. Not to us, no, not to Portugal. Huh? Peter, sir. What did you say?
Lord,
Just give us 1 minute. We're
yes.
trying to locate the notes. We had
Yes,
made
yes.
some.
Lordship has noted it extensively.
Thank you. Can you just, for our recapitulation, can you just refresh what were the facts?
Yes, Lord, what happened? In the year 2024, first,
We were considering 7263, perhaps 7263.
7263.
Yes.
This one,
6117 is there,
6117.
but we were looking into the papers of 7263.
7.
Yes.
So what happened here? Lordship will find that this association, City Bus Owners Association, running their city buses in the metro city, they were directed to be rerouted from two routes. Route number 23 and route number 36. In the name that they are going to designate these two routes, or they have designated these two routes as green route. And therefore, they wanted that all these city buses, 167 city buses, which were fueled by diesel fuel city buses, should be compulsorily rerouted to some other routes, and there they will not be permitted to continue to ply their buses in these two designated routes.
What are the numbers?
Numbers are 23, route number
23 and 36.
and 36. 23 is from Khanapara to Dharapur via Ganeshguri, and 36 is Boshishta Mandi to Dharapur via Cottonwood. These two routes.
They will make it E route or what?
For e-bus
E-bus.
Seva scheme, they say under the PM e-bus Seva scheme, they designate these two routes as green routes, and therefore, no diesel fuel buses shall be allowed to ply, and hence they wanted that our buses should be rerouted compulsorily. We must surrender our permits. Those permits which are still valid, they wanted that they should be surrendered, and those will not be renewed, and they will have to be rerouted. What happened? First, this question is, now, when the permits were issued and the permits, period validity of the permits are still subsisting, whether the authority can issue such a direction that you should be mandatorily rerouted, that the route should be changed. Allegedly under section 72 of the MB Act, without formulating a scheme, without notifying it, without taking objections from the people and us. This is the basic question. They started in the year 2024. That time, they first directed that all 200 buses should be off-routed. Off-routed from the entire Gauhati routes, flying in the entire Gauhati routes. And therefore, they issued a direction that this will be off-routed. We approached this Honorable Court. This Honorable Court stayed it. Subsequently, they considered that yes, we allow you, you withdraw the petition. Withdrawn, and they allowed us those vehicles which were still interested to run. We have been running our vehicles there. Lordship, that is at this page 7 to 60 petition. Lordship will find at page 164, the orders. Order, initial order, and then the withdrawal order at page 175. Those were, here the facts are narrated in the interim order itself at page 165. 164 it started. And therefore, they allowed us to run and we were running. Court took the view at that time that you at any rate cannot, without giving any opportunity, just off-road these buses, and their action is illegal. Therefore, court stayed it and allowed them, but the liberty was granted to act in accordance with law. If they want that the some modifications of the terms of the permit is required. That is in accordance with law they should do. And thereafter, well, the action was initiated to off-road us from 1/1/2024. And thereafter they have withdrawn that. We were allowed to run. We were running it. And then they issued this order. Notice at page 87, Lordship has noted it earlier. Annexer 7,
21/11/25.
21/11/25. Here they said that notice for mandatory rerouting of your stage carriers permit so and so for these individual notices were issued that time
Yes.
to all the bus permit holders. That it says, which refers to the subject cited above and in compliance with the RTA Regional Transport Authority. It is the Regional Transport Authority has taken the call. Resolution dated 13/10/2025 issued under the purview of Section 72 of the Motor Vehicles Act 1988. I am directed to inform you that as part of Green City Bus Route Initiative to promote cleaner, safer, and more commuter-friendly urban transportation, diesel fuel city buses will be phased out from city bus route number 23, Khanapara to Dharapur, via Ganeshguri flyover, and route number 36, Basistha Mandi to Dharapur, via Paltan Bazar, with effect from 1st January 2026. Here arose the cause of action. We have come against this notices before this honorable court.
21/11/2025 is the impugned notices.
Yes, 21 November 2025.
87, page 87.
87. See, cause of action arose. Therefore, accordingly, they say your aforementioned vehicle will be currently plying on route number 23 shall mandatorily required to be rerouted in any one of the following routes of your choice as per the recommendations made in the joint inspection report submitted there. Therefore, your routes are 10 routes they have indicated, and number of buses which can slots available for that they have also shown. Therefore, you are instructed to appear before the office of the undersigned on or before 22/12/25 along with your original stage carrier's permit of your aforementioned vehicle and all relevant documents for mandatory road change so that your vehicle could ply on one of the aforesaid routes of your choice with effect from 1/1/2026. And then the important note, the choice of routes will be allotted on first come, first served basis, subject to slot availability. Any bus owner who fails to appear by the cut-off date, that is 22/12/25, will be allotted route randomly. Such owners shall be required to operate his or her bus on the randomly assigned route with effect from 1/1/2025. This is for your, this is urgent. Now, question is whether such a notice is at all valid or it is arbitrary and malevolent. That is the question your lordship will have to decide. Our case is that when you designate certain routes as a green route under a particular scheme called PM E-Bus Seva scheme, then you will have to follow the law as prescribed under Chapter 6 of the MB Act. I will come to it in details. I am giving your lordships the facts. Yes. Now, how they proceeded? Kindly see, my lord, one thing I will stress that they now in this notice, they say it is under Section 72 of the MB Act. But they in fact invoked Section 103 also. It was in the process, I will place from the record that they did it.
223 pages.
This section 72 comes in chapter 5. Okay. Yes. Control of transport vehicles. This control vests in the state government. Lordship, kindly see first section 66. It says necessity for permits. No owner of a motor vehicle shall use or permit the use of the vehicle as a transport vehicle in any public place, whether or not such vehicle is actually carrying any passengers or goods, save in accordance with the conditions of a permit granted or countersigned by a regional or state transport authority or any prescribed authority authorizing him the use of the vehicle in that place in a manner in which the vehicle is being used, provided that a stage carrier's permit shall, subject to any conditions that may be specified in the permit, authorize the use of the vehicle as a contract carriage. Now, we can skip over. And then Lordship will see 66A. This central government may develop a national transport policy consistent with the objects of this act in accordance with the state governments and other agencies with a view to establish a planning framework for passengers and goods transportation within such transport bodies are to operate, within which, establish a medium and long-term planning framework for all forms of road transport, identify areas for the development of transport improvement infrastructure across India in consultation with the authorities and agencies related to ports, railways, and aviation, as well as with local and state level planning, land holding, and regulatory authorities for the delivery of an integrated multimodal transport system. 3. Establish the framework of grant of permits and schemes. Establish strategic policy for transport by road and its role as a link to other means of transport. Identify strategic policies and specify priorities for the transport system and address current and future challenges. This is for the central government to develop a national transportation policy consistent with the objects of this act. Then 8 Lordship will see subclause 8. Safeguard the interest of the public and promote equity while seeking to enhance private participation and public-private partnership in the transport sector. This is one of the objectives. Now, '67. Power to state government to control road transport. 67 I am placing, madam. A state government having regard to the advantage offered to the public, trade and industry by the development of motor transport, the desirability of coordinating road and rail transport, the desirability of preventing the deterioration of the road system, and the promoting effective competition among the transport service providers. D is important, my lord, for me. Promoting effective competition among the transport service providers. We are transport service providers. There should be a space which will promote effective competition amongst the providers. May from time to time by notification in the official gazette issue directions both to the state transport authority and regional transport authority regarding the passengers' convenience, economically competitive fares, prevention of overcrowding, and road safety. It is the government who is to issue directions to the state transport authority or the regional transport authority. Any direction under subsection 1 regarding the fixing of fares and freights of stage carriers, contract carriers, and good carriages may provide that such fares or freights shall be inclusive of the tax payable by the passengers or the consignors of the goods, as the case may be, to the operators of the state carriers, contract carriers, or goods carriers under any law for its time being in force relating to tax on passengers and goods. Provided that the state government may subject to such conditions as it may deem fit, and with view to achieve the objectives specified in clause D of subsection 1, with a view to of subsection 1, relax or relax all or any of the provisions under this chapter. Notwithstanding anything contained in this act, the state government by notification in official gazette modify any permit issued under this act or make schemes for the transportation of goods and passengers and issue licenses under such scheme for the promotion of development and efficiency in transport. This 67(3), kindly see once more, my lord. Notwithstanding anything contained in this act, the state government may by notification in the official gazette modify and permit issued modify any permit issued under this act or make schemes for the transportation of goods and passengers and issue licenses under this scheme for the promotion of development efficiency of transport. ABCD, transportation, that's it. Last mile connectivity, rural transport, reducing traffic congestion. These all that. I, the protect and enhancement of the environment, the protection and enhancement of environment. These are important. It is the government, state government, who retains this authority to issue directions, notify a scheme, and modify any permit. Regional Transport Authority or the State Transport Authority has no power to do that. This power is retained by the state government. For these purposes mentioned at A to M. M4. Then Lordship will see 4. The scheme framed under subsection 3 shall specify the fees to be charged, form of application and grant of a license, including the renewal, suspension, cancellation, or modification of such license. Therefore, the scheme is very detailed and it must provide for all that. Now, transport authorities under section 68, the state government shall by notification in the official gazette constitute for the state a state transport authority to exercise and discharge the powers and functions specified in subsection 3 and shall in like manner constitute regional transport authorities to exercise and discharge throughout such areas in this chapter referred to as regions, as may be specified in the notification in respect of each regional transport authority, the powers and functions conferred by or under this chapter on such authority. Provided that in the union territories, the administrator may abstain from constituting a regional transport authority. Now, therefore, it provides only that the state government shall not, by notification, constitute state transport authorities and regional transport authorities for the purpose of discharge and discharge the powers and functions specified in subsection 3. Subsection 3, as I have read out. Well, if a scheme is,
No, this subsection 3 is not of this.
sorry,
Subsection 3 is of 68.
yes.
Not of the earlier
Yes,
one.
not of the earlier, yes, yes.
68.3.
3 of self like manner. I'm grateful, Mal. 68.3. Now 3, if we read, the state transport authority and every regional transport authority shall give effect to any directions issued under section 67, and the state transport authority shall, subject to such directions and save as otherwise provided by or under this act, exercise and discharge throughout the state the following powers and functions, namely, to coordinate and regulate the activities and policies of the regional transport authorities, if any, of the state, to perform the duties of a regional transport authority where there is no such authority, and if it thinks fit or if so required by a regional transport authority to perform those duties in respect of the route common to two or more regions, to settle all disputes and decides all matters on which differences opinions arise between regional transport authority and CA, government to formulate routes for flying stage carriages. Government to formulate routes flying stage carriages to discharge such other functions as may be prescribed. Therefore, now kindly see, the state transport authority or regional transport authority can discharge their duties, exercise powers for this purpose, and yet say government to formulate routes for flying stage carriers. In that case, whatever directions comes, policy comes, it is for them to implement it. They are the implementing authorities, unless they formulate their own with the approval of the government. It is the government who retains the power, not the state transport authority or the regional transport authority. Now then, kindly see 70. 70 says application for stage carriers permit. An application for a permit in respect of stage carriers in this chapter referred to as a stage carriers permit or as a reserved stage carriers shall, as per as may be, contain the following particulars, namely the route or routes or the area or areas to which the application relates. They have to specify the route asking for a permit. The type and seating capacity of each such vehicle, the minimum and maximum number of daily trips proposed to be provided, and the timetable of the normal trips. We can explanation we can skip. The number of vehicles intended to be kept in service, the reserve to maintain the service and to provide for special occasions. The arrangements intended to be made for the housing, maintenance, and repair or all such other matters as may be prescribed. An application referred to in subsection 1 shall be accompanied by such documents as may be prescribed. Now, 71, procedure of regional transport authority in considering application for stage carriers permit. Here it says 1, a regional transport authority shall, while considering an application for a stage carriers permit, have regard to the objects of this act. And I will invite your lordship attention to 3, subclause 3. A, the state government shall, if so directed by the central government, having regard to the number of vehicles, road conditions, and other relevant matters, by notification in the official gazette, direct a state transport authority and a regional transport authority to limit the number of stage carriers generally or of any specified type, as may be fixed and specified in the notification, operating on city routes in towns with a population of not less than 5 lakhs. So it is applicable here in our city because it is more than 5 lakhs. Now, the state government shall, if so directed by the central government, having regard to the number of vehicles, road conditions, and other relevant matters, by notifications in the official gazette, direct a state transport authority and a regional transport authority to limit the number of stage carriers, generally or of any specified type, as may be fixed and specified in the notification. Here, nothing of that sort had happened. This power was never exercised.
No, this is an additional power that if the central government
central
wants,
government
they can direct the state government and through the,
Why?
by routing it through the state government,
True.
that means the
Why?
jurisdiction is not only limited to the state government, even the central government can.
also, the central
Yes.
government will issue direction to the state government.
Yes,
Why I am submitting? Here they say that it is the PM's e-Seva service scheme.
Correct,
That central government sponsored scheme.
correct.
What they call it e-Seva scheme, they have sanctioned some fund and they are to make purchases of those e-buses. E-buses. If this is so, there must be a direction to the state government to implement it. And state government is required to formulate a scheme and accordingly direct. issue the direction. In that context only I am referring to this,
Yes.
that context. Now, but then I have informed this honorable court that there was nothing of this sort has happened. State government has not issued any direction, no notification, nothing of this sort. They have also not placed on record any such notification so issued by the central government or any notification issued by the state government.
Central government, according to you, there was no direction from the
They
central
have
government.
not placed it. It is nothing comes to on public forum. Nothing. Nothing comes.
Madam, are you following, Bora? Are you following what senior counsel is saying? You're not following, you're talking. Follow it, we'll need your response. Important point he's raising. It's a scheme of this PM, E-Seva. And there is also provision of 71(3), where the direction can be given by the central government to the state government. Senior counsel is saying that there is nothing on record to show that such direction has been given.
In such matters, Lordship may also like to just ponder on the other provisions so far. Subsection 3, B, C, D. I will just indicate how to go about, what are the considerations which are to be borne in mind in formulating such schemes, and what is the purpose. They have indicated where the number of stage carriers I am reading at page 3B. Where the number of stage carriers are fixed under clause A, the government of the state shall reserve in the states certain percentage of stage carriers permits for the scheduled caste and the scheduled tribes in the same ratio as in the case of appointments made by direct recruitment to public services in the state. C. Where the number of stage carriages are fixed under clause A, the regional transport authority shall reserve such number of permits for the scheduled castes and scheduled tribes as may be fixed by the state government under subclause B. D. After reserving such number of permits as is referred to in clause C, the regional transport authority shall, in considering an application, have regard to the following matters, namely financial stability of the applicant, satisfactory performance as a stage carriers operator, including payment of tax if the applicant is or has been an operator of stage carrier service, and such other matters as may be prescribed by the state government, provided that other conditions being equal, preference shall be given to the applications for permits from stage transport undertakings, cooperative societies registered or deemed to have been registered under the enactment of for the time being in force, ex-servicemen, any other class or category of persons as the state government may for reasons to be recorded in writing consider necessary. Explanation: for the purpose of this section, company means any body corporate and includes a firm or other associations of individuals, and director in relation to firm means a partner in the firm. So it includes it has made an attempt to include all, including those downtrodden in the society.
Yes.
Then kindly come to 72. They are hopping on this.
Yes, this will be the important point.
Grant of stage carriers permit. 1. Subject to the provisions of section 71. A regional transport authority may, on an application made to it under section 70, grant a stage carriers permit in accordance with the applications or with such modifications as it deems fit, or refuse to grant such permit. So kindly note it again. Regional transport authority may, on an application made to it under section 70, grant a stage carriers permit in accordance with the application or with such modifications as it deems fit, or refuse to grant such permit. Lordship has noted 70, the route should be specified and all the other conditions should be specified. Provided that no such permit shall be granted in respect of any route or area not specified in the application. Therefore, the very clear provision is that the permit shall be road specific. Permit should be road specific. The road must be prescribed, must be mentioned, including its descriptions, and in respect to only that, no other. Else, that application can be rejected. But if they are to grant the permit, that road specific permit shall be granted. 2. The regional transport authority, if it decides to grant a stage carrier permit, may grant the permit for a stage carrier of a specified description and may, subject to any rule that may be made under this act, attach to the permit any one or more of the following conditions, namely, 1. That the vehicle shall be used only in a specified area or on a specified route or routes. Kindly take note of it. Again, it is, my lord, reiterated. Whatever is the provision, 72 provision has been say provided. That proviso is repeated here. This is the condition. That it is road specific or area specific. Then we can skip over these other conditions. Lordship will come to 22, that condition, because they are calling on this to take the advantage that we have the power. It says that the regional transport authority may, after giving notice of not less than 1 month, vary the conditions of the permit. B. Attach to the permit further conditions, provided that the conditions specified in pursuance of clause 1 shall not be varied.
Yes.
It shall not be varied so as to alter the distance covered by the original route by more than 24 kilometers. And any variation within such limits shall be made only after the regional transport authority is satisfied that such variation will serve the convenience of the public and that it is not expedient to grant a separate permit in respect of the original route as so varied or any part thereof. So these conditions, what are the conditions? Conditions can be attached as from 1 to 24, but it makes first thing, number 2(1), that the vehicle should be road specific. It must be, a road should be specified. And 22 says that it can, after giving notice, vary the conditions of the permit, but these conditions will not include 2(1), except shortening the distance. Except shortening the distance, you cannot change the route. Therefore, it says, vary the conditions of the permit, attached to the permit further conditions, provided that the conditions specified in pursuance of clause 1 shall not be varied so as to alter the distance covered by the original route by more than 24 kilometers. That means it is very clear interpretation, general English, that route is already specified. You can, if necessary, cut short the distance. But this is also not more than 24 kilometers. Limitation is there. Not more than 24 kilometers. You can cut short it, but you cannot change the route. Therefore, variation of conditions of the permit would not include total uprooting of the bus from that particular route. My full submission is, one cannot claim that when I have a power to to modify the conditions or vary the conditions of the permit, I can altogether change the route and throw you to some other. No, this is not permissible. There is a decision of the apex court, I will place it. It cannot be done. It cannot be done. Otherwise, 70 will be meaningless. When you issue a permit, road specific, what for? Now, therefore, then in that case, if they want to vary, if they want to change the routes mandatorily, is there any such provision in the Act? Let us see that. And that is provided under Chapter 6. Before that, before I take your lordship to Chapter 6, let me read other two provisions. Lordship will kindly see 81, Section 81. Duration and renewal of permit. Lordship, Malab.
Yes.
Yes. A permit other than a temporary permit issued under Section 87 or a special permit issued under subsection 8 of Section 88 shall be effective from the date of issuance or renewal thereof for a period of 5 years. This is the time limit. 5 years. Normal tenure of a permit is 5 years. Now kindly read 2. A permit may be renewed on an application made not less than 15 days before the date of its expiry. Therefore, before expiry, if one approaches that before 15 days, then it should be considered. Three, notwithstanding anything contained in subsection 2, the Regional Transport Authority on the State Transport Authority, as the case may be, entertain an application for the renewal of a permit after the last date specified in that subsection, if it is satisfied that the
Not
applicant...
necessary. These are not necessary.
Yes. Regarding, I want to only place before this court that according to law, the 5 years tenure of a permit is there and that can be renewed. We were granted subsequently for 4 months, temporary permit. 6 months. Yes. Temporary permits, how to issue it? '86, Lordship may also see. Cancellation and suspension of permit. The Transport Authority which granted a permit may cancel the permit or may suspend it for such period as it thinks fit on the breach of any condition. These conditions are there. So on the breach of any of these conditions, they can, provided that no permit shall be suspended or cancelled unless an opportunity has been given to the holder of the permit to furnish his explanation. This has not been invoked. This provision has not been invoked, and no such notice that you are liable to be cancelled.
But it is not a case of cancellation or suspension.
Yes, not that. Therefore, but if they want, they will have to fall back on this particular provision. They have not done.
You can place the relevant case, the provisions.
Yes.
86 perhaps will not have any application here.
Oh.
Duration, you have said 81 would be applicable. 5 years is the normal tenure.
Yes.
And there's a renewal clause.
Yes.
With an extra power of condoning the delay in case of there is a delay.
Delay. That can be done. Then temporary permit 87. Temporary permit, a regional transport authority and the state transport.
Is it relevant for the case?
Yes, they have issued temporary permit to us, limiting the period and for 6 months, not beyond 6 months, only 6 months, 6 months. But law says that in any case, it cannot exceed 4 months. It says a regional transport authority and the state transport authority may, without following the procedure laid down in section 80, grant permits to be effective for a limited period, which shall not in any case exceed 4 months to authorize the use of a transport vehicle temporarily. So their action to limiting it to 6 months is also not sanctioned by law. And in such cases, if they do take action, then appeal lies under section 89, the remedy is provided. If
But
any action-
here, so far as temporary permits are concerned, though the law prescribes 4 months, you have been given 6 months. Perhaps you will not be aggrieved by this.
No, my lord, my response submission is the purpose for which the temporary permit is issued must be specified. And if that is so, they are to act in accordance with law. 4 months basis, they can go on. They cannot abruptly choose on their own.
That you have made it clear.
Yes, that is what I want.
That you have conveyed to the
cannot.
court.
They cannot just
That
arbitrarily
you have
on their
conveyed.
whims and fancies fix a time, because what they have done it here. Oh, your permit will be expiring on 31st December this year. Now there are 8 months to go. I'm giving it only for 6 months, not to that time. This is how they are doing. Then next 6 months is not there and I will be out. This is how they have taken the whole course to see that we are compelled to go out of these routes. These actions as such doesn't speak good as regards the intent of the authority to implement.
Mr. Mahanta rehearsed your arguments on the principles of law or on the legality. They had offered alternative routes. Were you agreeable to the alternative routes?
Alternative
In fact,
routes.
you were plying. Last time you had said that you were plying, compelled to ply.
Yes.
Now, this is without even entering into the merits,
Yes.
broad thinking. If the matter can be settled, if there is a policy to make 2 routes green routes,
Yes.
it may not be a.
Well, Lord,
You
I
cannot-
have.
And in
no
fact, you have also not found fault that you can make green roads, but give us also that opportunity. Perhaps
Yes,
you can
now
also.
how they are doing it. Now question is, my lord. So
Now,
far-
now the what we were trying to get from you, that you are plying your bus in some alternative routes. May not be convenient to you,
Yes.
but do you have any suggestion in that regard that via media can be reached, wherein without requiring to answer the questions, the issues which you have raised on merits, we can direct the state to do something for you? Because from the date of filing, 25, we have more than almost a year has passed. That,
Yes.
of course, will not come in the way of if you go to decide on merits. But on a broader interest,
My lord, may I submit? The alternative routes which are provided to them may not be that beneficial.
correct.
And therefore, most of them, some of them rather, have already sold out,
Hmm.
given up.
Hmm.
Their whole livelihood has been affected
Hmm.
because of this action.
Hmm.
So the arbitrary and illegal action has led to the frustration and losing of employment to so many persons. Such actions, if allowed to continue by violating the law, then it will have a disastrous.
How many
effect on the
members do you
society.
have?
We have initially 167 assets. More
And
than
how
200.
many buses are presently with your members? You said some of the members had to sell their buses.
Yes, yes, yes.
Now, how many
in
are
their
remaining?
document itself, they showed that some 49 or 89. This is what they have said. I'll take your lordship to that also. I'll to that also. At least let us say 50 buses are now there. 50 buses are now there. Assume. Therefore, and they said that now because you come, we will place you wherever we like. You will have to apply. If I want to do business, yes, but this business is not a business like any other kind. It is service to the people also. It is service to the people also. And it must be such that it is viable. A vehicle will ply, and if it is not viable for him, not profitable for him to meet the expenses of the persons involved in a particular bus, then it would be definitely not possible for him to continue with. This has happened now. This has happened. Therefore, if ultimately, my lord, we as such, if had it been so that they have followed the law, our objections were heard, probably we would have been given some benefit, either giving some financial aid to convert ourselves, or to replace us by paying compensation under the law. They have not done anything. They have simply by force ousted us. There lies our grievance. We are not cooperating with the government. The authority must act in accordance with law, so that the action will be balanced. They have not totally looked into the plight of these people. Therefore, kindly see, my lord, I want to press on merit, because this is what was the instruction of my clients, that it should be, because there will be those who will continue in such business, they will be always in a position that we may at any time be thrown out from any route tomorrow. That should not happen. There should be something from this honorable court that no, follow the law, because law is very specific and it prescribes for. I cannot stick to a particular route on the basis of their permit. If they, by following the due process, say that no, now because of this, you will have to change. But this was not done. This was not done. Therefore, my lord, kindly see, my case is that the 72 could not have been invoked, section 72, to offload us. By no stretch of imagination, one can say that 72 gives the power to the state transport authority or the regional transport authority to change the route when the valid permits are standing, holding the field in those specific routes. Kindly come to now, Malad, chapter 6. Special provisions relating to state transport undertakings.
Chapter 6 starts with which section?
97.
97.
97. First is definition.
Yes.
In this chapter, unless the context otherwise requires, quote unquote, road transport service means a service of motor vehicles carrying passengers or goods or both by road for hire or reward. 98, chapter to override chapter 5 and other laws. This has the overriding effect. The provisions of this chapter and the rules and orders made thereunder shall have effect, notwithstanding anything inconsistent therewith contained in chapter 5, or in any other law for the time being in force, or in any instrument having effect by virtue of any such law. So, we have read Malad chapter 5. Chapter 5 gives the controlling authority, to the state. So these are other bodies. It says this chapter will have an overriding effect on all the laws, including chapter 5. Then 99 is important. Preparation and publication of proposal regarding road transport service of a state transport undertaking.
90?
9.
Okay.
99.
Yes.
Where any state government is of opinion that for the purpose of providing an efficient, adequate, economical, and properly coordinated road transport service, it is necessary in the public interest that road transport services in general or any particular class of such service in relation to any area or route or portion thereof should be run and operated by the state transport undertaking, whether to the exclusion, complete or partial, of other persons or otherwise, the state government may formulate a proposal regarding a scheme giving particulars of the nature of the services proposed to be rendered, the area or route proposed to be covered, and other relevant particulars respecting thereto, and shall publish such proposal in the official gazette of the state, formulating such proposal, and in not less than one newspaper in the regional language circulating in the area or route proposed to be covered by such scheme, and also in such other manner as the state government formulating such proposal deem fit. So this is the power given to the state government. 2. Notwithstanding anything contained in subsection 1, when a proposal is published under this subsection, then from the date of publication of such proposal, no permit shall be granted to any person, except a temporary permit during the pendency of the proposal, and such temporary permit shall be valid only for a period of 1 year from the date of its issue or till the date of final publication of the scheme under section 100, whichever is earlier. These provisions are there, Amal. Then it says that in that case, it will be limited permit.
But here
Temporary.
the period is for 1 year.
Here it is because the whole process to complete. Therefore, that period, if necessary, it says that 1 year from the date of issue or till the date of final publication. That is because it has been left open so that authority can, till it is finalized, keep on issuing permit temporarily, not no final or permanently will be permit will be granted. Now 100. Objection to the proposal. On the publication of any proposal regarding a scheme in the official gazette and in not less than one newspaper in the regional language circulating in the area or route which is to be covered by such proposal, any person may, within 30 days from the date of its publication in the official gazette, file objections to it before the state government. The state government may, after considering the objections and after giving an opportunity to the objector or his representatives and the representatives of the state transport undertaking to be heard in the matter, if they so desire, approve or modify such a proposal. 3. The scheme relating to the proposal as approved or modified under subsection 2 shall then be published in the official gazette by the state government making such scheme, and in not less than one newspaper in the regional language circulating in the area or route covered by such scheme, and the same shall thereupon become final on the date of its publication in the official gazette, and shall be called the approved scheme, and the area or route to which it relates shall be called the notified area or notified route. Now here, my lord, they call it designated route, but it's a notified route that should be considered under the law. Designated it, they have designated it. Who? the regional transport authority. They have designated it and say, we make it a green route. Is it not necessary for them to issue a notification to that extent? What are the conditions? What are the considerations which played the minds of
Rather, you have said that the power, if any, is vested with the state.
With the state government.
Almost central to direct the
Already
state.
said, yes.
RTA has not
No.
has been not been vested with
They
the
do
power.
not have power, any power. They do not have regulatory power again.
That is your basic argument.
Exactly. It is without authority. They have acted beyond their authority.
You are challenging the jurisdiction.
Yes. I'm challenging the jurisdiction. What you've noted earlier, that point also. First point, that they do not have the authority to issue such notification, to take such actions, which are arbitrary and malafide in law and facts.
So if you succeed on the point of jurisdiction, you may not, you may restrict your argument not to go to challenging the policy, because the
There is no
contours of
policy as such.
policy, that the scope of our judicial intervention will less. But if you can make out a case of jurisdiction,
Yes. Following the law, had there been a policy, the question would have been whether that policy has been formulated in accordance with the law, or it is published, or the process has been followed or not. I cannot challenge the policy here. Now the question is, they do not have a policy as such. They suddenly decide on a fine morning that, well, we designate these two routes as green routes, and you all go. Or you come up with e-buses, which is impossible. They are trusting a burden on us, which is not possible for us to complete. Is it fair? Supreme Court says, no, it is unfair. You cannot trust a burden on
how
us.
much time was given to you?
We were given 1 month's notice to reroute.
1 month.
1 month. 1 month notice. That you go. That is why the notice said. Now, therefore, my lord, and kindly see little more two provisions.
Let him complete.
103,
103.
103.
Section 103.
Yes. Issue of permits to the state transport undertaking. 1. Where, in pursuance of an approved scheme, any state transport undertaking applies in such manner as may be prescribed by the state government in this behalf for a stage carrier's permit, or a goods carrier's permit, or a contract carrier's permit in respect of a notified area or notified route. The state transport authority in any case where the said area or route lies in more than one region, and the regional transport authority in any other case shall issue such permit to the state transport undertaking, notwithstanding anything to the contrary contained in chapter 5. They can apply and then will issue. 2. For the purpose of giving effect to the approved scheme, kindly mark it, in respect of a notified area or notified route, the state transport authority, or as the case may be, the regional transport authority concerned, may by order refuse to entertain any application for the grant of renewal of any other permit, or reject any such application as may be pending. This power is now available to them to reject or not to act upon, renew, not to renew, cancel any existing permit. B. Cancel any existing permit under this special provision. This is a special provision, my lord. This power is given to them. Modify the terms of any existing permit so as to, 1, render the permit ineffective beyond a specified date, which they have done here. Reduce the number of vehicles authorized to be used under the permit. Curtail the area or route covered by the permit insofar as such permit relates to the notified area or notified route. Here only this power comes to curtail the area or to the route itself. They can be uprooted, notwithstanding having that particular the permit existing for a particular period. They can take this action here. 3, 2, 3. Roman 3. Curtail the area or route covered by the permit insofar as such permit relates to the notified area or notified route. For the removal of doubts, it is hereby declared that no appeal shall lie against any action taken or order passed by the State Transport Authority or a regional transport authority under section 1 or subsection 2. No appeal lies here. And this power can be invoked only when there is a scheme notified and after hearing this has been finalized for the implementation of the scheme, not otherwise. Otherwise, chapter 5 will hold the field always. This power comes under the special provision of chapter 6. Chapter 6. Otherwise, chapter 5 is always to be applied. Now, under such circumstances, the legislature has further visualized what will happen. It says 104, section 104. Where a scheme has been published under subsection 3 of section 100 in respect of any notified area or notified route, the State Transport Authority or the Regional Transport Authority, as the case may be, shall not grant any permit except in accordance with the provisions of this scheme. Then it is nobody can apply except this scheme, whatever is provided there. Others are not allowed. Provided that where no application for a permit has been made by the state transport undertaking in respect of any notified area or notified route in pursuance of an approved scheme, the State Transport Authority or the Regional Transport Authority, as the case may be, may grant temporary permits to any person in respect of such notified area or notified route, subject to the condition that such permits shall cease to be effective on the issue of permit to the state transport undertaking in respect of that area or route. The temporary arrangement they can make. Now, another important provision is 105 section. Principles and method of determining compensation and payment thereof. 1. Where, in exercise of the powers conferred by clause B or clause C of subsection 2 of section 103. 103 you have read, Mala. Any existing permit is cancelled or the terms thereof are modified, there shall be paid by the state transport undertaking to the holder of the permit compensation, the amount of which shall be determined in accordance with the provisions of subsection 4 or subsection 5, as the case may be.
But are you really praying for compensation?
Well, we have suffered greatly, no doubt about it, because it has a telling effect on all these bus owners, because suddenly they had undergone a serious jerk, change. Their livelihood was badly affected. Many people got frustrated.
No, are you praying for compensation?
Yes, we prayed for.
You heard.
We submitted our representation. We prayed for. I'll take your lordship to that also. I'm placing this law. Then lordship will see the factually whether I prayed or not. I have submitted our representation. In representation, I found that they prayed for. Then 2, it says, subsection 2, 105 subsection 2, notwithstanding anything contained in subsection.
We did not find any prayer for compensation.
Well, here we have not made. Prayer is not there, but our representation, it was there before the authority. Before the authority, that was there. Even they have taken note of. I will place it.
But since compensation is not one of the parts which
the
is
prayer.
urged in this petition, we can avoid this compensation part.
Well, in my respectful submission, lordship may always see the consequences following and provisions made by the law for that to take care of this. In that, lordship will kindly come in. My respectful submission is this. If Lordship ultimately finds that no, to balance the equity, this is required. Law provides for in such a situation. If they forcefully oust me, what to do? I cannot fight against the mighty government. Therefore, I am compelled against my will and in violation of the rules, laws, then what is to remain? Law provides in such circumstances that compensation should be paid. Notwithstanding anything contained in subsection 1, no compensation shall be payable on account of the cancellation of any existing permit or any modification of the term thereof when a permit of an alternative route or area in lieu thereof has been offered by the state transport authority or the regional transport authority as the case may be and accepted by the holder of the permit. That must be accepted. Those who have accepted, I have nothing to say for them. But those who have not accepted, the authority is to look into it. For the removal of doubt, it is hereby declared that no compensation shall be payable on account of the refusal to renew a permit under clause A of subsection 2 of section 103. Refusal of renewal, I am not claiming because they have the power. Provided they have acted under chapter 6. Now, 4, my lord, subsection 4, where in exercise of the powers conferred by clause B or clause 1 of subclause 2 of clause C of subsection 2 of section 103, any existing permit is cancelled or the terms thereof are modified so as to prevent the holder of the permit from using any vehicle authorized to be used thereunder for the full period from which the permit would otherwise have been effective, the compensation payable to the holder of the permit for such vehicle affected by such cancellation or modification shall be computed as follows. They have laid down the guidelines, how to commute. Here also, when our term was existing up to 29, 28, 29, they have cancelled it. They have not allowed us. It says A, 4A, for every complete month or part of a month exceeding 15 days of the expired period of the permit, 200 rupees. For part of a month not exceeding 15 days of the unexpired period of the permit, 100 rupees, provided that the amount of compensation shall be in no case be less than 400 rupees. And then they have laid the formula here, 5, wherein exercise of the powers conferred by subsection 3 of clause C of subsection 2 of section 103, the terms of an existing permit are modified so as to curtail the area or route of any vehicle authorized to be used thereunder. The compensation payable to the holder of the permit on account of such curtailment shall be an amount computed in accordance with the following formula, namely y into A by 4R. Y means the length of the area by which the route or area covered by the permit is curtailed. A means the amount computed in accordance with subsection 4. R means the total length of the route or the total area covered by the permit. The amount of compensation payable under this section shall be paid by the state transport undertaking to the person or persons entitled thereto within 1 month from the date on which the cancellation or modification of the permits becomes effective, provided that where the state transport undertaking fails to take the payment within the said period of 1 month, it shall pay interest at the rate of 7% per annum from the date on which it falls due. And disposal of articles and all those are there. Therefore, this is the scheme of the law. Now, that being the scheme of the law, whether the authority can get escape from this while acting under this. Now they have said in this notice I have shown at page 87 that they have acted section 7 under section 72 of the Motor Vehicle. But in fact, I will take that they were invoking 103 also, section 103. They were acting under 103. Last time when I was submitting, when they issued notice to us, their affidavit, Lordship will kindly take up the affidavit in opposition,
Filed in 6117.
filed in 6117, my lord. They submitted it in our first writ petition.
Which page? Hmm?
123.
In 6117.
Yes. Affidavit in opposition.
223.
This was a notice issued to one of the petitioners, the holders, permit holders. Here, notice regarding rerouting of your permit number so and so against your vehicle bearing,
Affidavit starts at which page, madam?
my lord, 223.
No, affidavit starts at
Affidavit,
118.
118,
8.
yes.
And you are referring to 223.
Three. To answer this, whether they acted only 72 or 103. Sorry. Also got it, my lord.
Just a minute, please. Yes.
Yes, 223, this was a notice. It was 28 March 2024. Now, here, they have said, subject, notice regarding rerouting of your permit number so-and-so, your vehicle bearing registration number so-and-so, as per the provisions under section 72 and 103 of the MB Act. 103 of the MB Act. Subject, in the subject they have mentioned it.
Yes.
103. Here they say, with reference to the subject cited above, I have the honor to inform you that a notice has already been issued by the undersigned under section 72 of the MV Act, where you were directed to present before the undersigned on 18/24 for personal hearing, give you an opportunity to be heard. Since you had not appeared before the undersigned for the said hearing, your vehicle will be rerouted on one of the eight outside city bus routes, namely so and so, so and so, so and so, based on the resolution of one of minutes of the RTA board meeting, so and so, held on 19/24. For this purpose, a lottery will be conducted by the lottery committee of 5/4/24 at 3 p.m. and the office of the undersigned to bring transparency in the process of rerouting. Therefore, you are directed to present before this undersigned on the aforesaid date of time for rerouting of your vehicle as per provisions under section 72 and 103 of the MV Act 1988.
Yes.
So all these notices thereafter, Lordship will have 223, 224, 225. I have given some notices.
Yes.
They acted under 103. They invoked 103. 103 can only be invoked if they have acted under section 99 and 100 first. That means they were aware that otherwise they do not have the power.
Yes.
Then we, against this notice, we represented at page 226. Their affidavit itself, my lord. This was addressed to the District Commissioner, Kamrup Chairman, Regional Transport Authority, 18th day of November 2024, prayer for retention of the same routes permit of our vehicles having periodic permits. We have narrated the entire incidents coming to the court and all in first two paragraphs. And then page 227, last para, that we regret to state that we, being the citizens of a welfare state, where the state has the responsibility to justice and welfare of the citizens by utmost effort to give employment to the educated unemployed youths, such arbitrary decision on the part of the RTA Metro had adversely affected the life and liberty of our members who, on the other hand, by taking huge loans from different financial institutions at an exorbitant rates of interest to do noble business of their own by giving employment to 3 other families for each bus, besides paying a huge amount of money by way of road tax, insurance premium, permit fees, etc. That such arbitrary decision on the part of the RTA Kamrup Metro rather discourages self-employment and added to more unemployment. Therefore, in the premises aforesaid, I would like to pray that your good office be graciously pleased to relocate the same route permits to the remaining city buses, around 50 in number out of the 200 numbers of city buses which are banned to be phased out and obliged. This was our representation. That time we mentioned about 50 because by that time others have surrendered. Most of them have sold out. These are the numbers were given at page 280. They have given this. Bus numbers, owners,
Page
page 280, my lord.
280.
Following this representation, yes, 280. 280 or 230?
No, not 280.
230, my lord, sorry.
230.
It looks like 280 page. 230. Now, that is the position, and one thing I would like to point out to your lordship from their document itself. When I was submitting on the last occasion, I was referring to page
13, 10, 20,
hmm,
182,
182.
82, last year.
182. Yes. I was referring to page 182 of their affidavit.
6117 itself.
Yes, yes. They have filed this affidavit only.
Yes.
Yeah,
Affidavit starts at 118.
yes, yes.
Which part of the affidavit you want to refer?
My lord, these minutes of the
RTA board,
RTA board dated 13/10/2025
Page
at page 182.
182.
182.
Yes.
Yes.
This is 183 at page, lordship will find designation of city bus route number 23 and 36 as green routes. Second column, my lord, topic. Then from top I am reading after careful
This is 16th of October.
Yes.
13, 10,
16.
13/10/2025.
16/10.
16th October they have.
Or it is communicated, the meeting is of 13th of October.
13th of October 2025.
25,
Yes,
minutes of meeting,
yes.
RTA board.
RTA board. RTA has taken the call, my lord. There was nothing from. I placed earlier a cabinet decision. Lordship has taken note of. I will take your lordship later on. But lordship, can you see that also never says that this scheme is floated or go by this. Nothing. Just to explore possibilities.
Here at 183, what do you want to show?
Here only they said, the 183, after careful consideration of all the previous resolutions taken in RTA board relating to green route resolutions, the RTA board approved the following additional directives. They issued additional directives. Current status of diesel fuel city buses plying in route number 23 and 36. The DTO and Secretary RTA Kamrup Metro informed the RTA board that out of 158 numbers of diesel operated city buses which are plying on route number 20 and 36, 4 number of buses had already been rerouted and 32 numbers of applicants had already submitted undertaking for route change prior to 1st January 2026. As I submitted earlier, by coercive method, they have done it. They have not denied it. Route feasibility report. The DCP Traffic Gauhati is instructed to conduct a detailed inspection of all the city buses routes. Lordship may skip over that part. Now, 3. Notices to individual owners. Upon receipt and approval of the feasibility report by the Honorable Chairman RTA Board, Metro, the DTO Secretary RTA may issue individual notices to those vehicles owners who have not rerouted their buses or fail to submit undertakings agreeing to reroute their buses from route number 23 and route number 36 as per section 72 of the Motor Vehicle 1998 and the rules framed thereunder. This was the decision taken, therefore they have issued notices, and these notices also mention about section 103.
Only 72.
Hmm?
72. After 72.
No. Individual notices. No.
Okay.
Hmm. Then they have annexed this High Court first order of the learned single judge, page 190. Lordship may skip over. Lordship earlier read it.
Decision could have- Cabinet decision.
I need it to come. Prior to that, they have annexed that to at page 199. This was the, again, minutes of the RTA board dated 12 February 2024. Here also, they have said at C, page 200, my lord. 1C, paragraph. The Honorable Chairman, after further directed the DTO and Secretary RTA Kamrup Metro to strictly follow the provisions of MV Act
Where are you reading 200?
200, my lord. First
See, okay, okay.
paragraph.
Yes.
The Honorable Chairman further directed the DTO Secretary RTA Kamrup Metro to strictly follow the provisions of the MV Act 1988 while allowing for route change, and only after the approval of the RTA Board Kamrup Metro based on the report from the DCP Traffic Kamrup Metro. A notice in this regard will be given to all the diesel operated private city buses falling under the 200 removed buses whose permits will be rerouted. Earlier, 200 buses were removed. In their respect, they said that issue notice and reroute them. This was the resolution they took. This has been annexed by them. And then This is important at 202 also. This is another minutes of the meeting dated 21st March 2024.
March.
Yes, 19th March 2024. This was the minutes of that meeting. This meeting has amongst others has said like this. Let that page 203 C 1C. One says 1A, the DTO and Secretary RTA Kamrup Metro placed the matter of rerouting of approximately 125 numbers of diesel operative city buses out of the 200 numbers of private city buses, from which 69 of the permits were cancelled, failed, and 6 city buses owners voluntarily changed their city bus routes, against which opportunity for hearing was conducted on 18/24 at the office chamber of the DTO Secretary, RTA Kamrup Metro. They say that 69 numbers of permits were cancelled. Those were cancelled, and 6 city bus owners voluntarily changed their, not all. B says the ACT Assam and DTO Secretary RTA Kamrup Metro, Srimati so-and-so, further requested the Honorable Chairman to accommodate the 125 number of city buses in the following 8 outside city bus routes. And then kindly go to 203C. In this regard, the Honorable Chairman RTA Kamrup Metro gave the following instructions. Direction, sorry. The DTO and Secretary RTA Kamrup Metro could accommodate the aforesaid 125 numbers of private city buses in the 8 outside city bus routes based on the provisions of the section 72 and 103 of the MV Act 1988. So they want to accommodate 103. If they follow, they can cancel the licenses and no permit will be issued, no permit, the route can be changed. As the owners were provided with a notice period of more than 1 month. Moreover, the completion of the flyover would be also beneficial in better streamlining of these city buses. Therefore, section 103, they acted upon. Section 103, 72 and 103. Now, well, who is running? Kindly see, this is another aspect. This e-buses being run by whom? Their own document, page 205. This is the minutes, a part of the minutes of the same document, my lord.
Yes.
19th March 2024.
Where is the finding that who is running?
Page 205, my lord.
Yes.
6. With
6.
regard to the irregularities in management and streamlining of ASTC buses, the Honorable Chairman gave the following directions. ASTC should immediately stop plying of its buses through the B. Borua Road, Gauhati so-and-so. Further, ASTC should also ensure that every driver and conductor should carry their respective licenses along with the relevant vehicles documents while on duty. B. ASTC should immediately submit their agreement deeds with the 2 private companies which are running the electric buses to the DTO and Secretary RTA Kamrup Metro within 3 working days, so that the RTA board could explore opportunities in modification of the agreement deeds in relation to disciplinary arrangements for the next financial year.
Okay, this is interesting. Okay, we take a 5 minutes break.
Yes. No financial arrangement.
Some twist.
Yes. I want to finish it.
This twist was not there on the last hearing.
No, no, gradually it is coming.
Private players are also there.
Private players are there. While going through minutely, I look at this. I said, oh,
Okay,
it is
let
there.
us see.
Fact, this was done by some private,
These green buses are not STC buses.
not STC buses. Pro STC, they say that in the name of STC, but those are being played by private companies. Their own document, two private companies which are running the electric buses. We do not know who are those two private companies. But fact remains now, it is clear that two private companies are taking the benefit of running these buses. In the name of E-Sewa, Prime Minister E-Sewa bus scheme. But in fact, those are buses are being plied by two private companies.
How was it given to a private company, madam? Was there any process undertaken, tender process? How did you choose?
Nothing of this sort. Oh, please, so, go on.
You may adopt to an E mode, green mode. How did you choose the companies? Madam Bora, you may adopt to the E mode, no problem. How did you choose the two companies? Was there any...
Instruction, my lord.
No, not the instruction. We have been hearing for... Was any tender process done?
That I'm not aware.
So
My
how did you
senior-
choose? You like somebody you choose.
That I'm not aware. My senior might have instruction regarding that because he has been engaged in this matter.
How many buses?
200.
200 buses you give it for on your liking.
Also, there must be some e-tender.
We would like to know there also.
Lordship, my senior.
You'd have that instructions also. Okay.
Yes. With my senior them also.
Yes.
And there, my lord, when we mention about our compensation, page 204, pre-page 2205,
Yes.
they rejected this saying, serial 4, my lord. With regard to the MTAG, that is motor transport.
That's
party.
you.
Yes, me. Seeking compensation due to the removal of 200 numbers of state carriers permits, VDA letter dated 28/12/2023. The Honorable Chairman stated that as the new executive committee of the MTAG Kamrup Metro was formed without following the provisions of law, based on the letter submitted by the Office of the Registrar of Farms and Societies, so and so. Therefore, the RTA board should not entertain any application received from this new executive committee. That's what they said. But we are a recognized registered society. That was done.
On
See-
merits, it has not been dealt with.
No. Simply said, no, we will not entertain. That at that time they take the plea, they will not recognize you. That is the plea. In 208 page, my lord, in that minutes of the committee dated 5/4/2024.
208.
Extract of the lottery conducted on 5/4/2024, day after this sitting was held, board's meeting. As per 19/3/2024, that proceeding. Here also they have mentioned.
This
first
is
paragraph.
another minutes of meeting of 5/4/2024.
Yes. In the office chamber of this DTO Secretary Kamrup regarding rerouting of 111 number of city buses in the outside city bus routes. Based on minutes of the RTA board meeting, Kamrup dated 19/3/2024. We have already read it, my lord. Here, first paragraph, Lordship will see, as per order number so and so dated 27 March 24, a lottery committee was formed by the Honorable Chairman RTA Metro for rerouting of the city buses on the lottery basis in the outside city bus road so and so, as per the provisions of section 72 and 103 of the MB Act 1988. Also, a representative from public was present in the event. This is what they say. And then next, last paragraph 2. The rerouting of city buses are carried out based on the provisions under section 72 and 103 of the MB Act 1988. '72 and 103, they invoke. Here they have said, next page, 209, out of the 200 numbers of city buses, diesel operated, 61 numbers of city bus permits were cancelled. See, suddenly 61 numbers were cancelled. What these people will do? 12 numbers of city buses have already expired stage carriage permits. 10 numbers of city buses were already rerouted by the respective city bus owners, and 6 numbers of city buses are already plying in outside city bus routes. Only 6 were plying. These 89 numbers of city buses are omitted from the lottery. So these 89 city buses were not taken care of. 111 numbers of city buses are randomly adjusted in the 8 outside city bus routes as follows. They have given these numbers, route numbers, next pages. Registration number, route number, they have mentioned in this. These are the buses they say. Then kindly come to page 217.
217.
Yes. The RTA board's meeting dated 7/6/2024. Here at last para of page 217, Roship will see that they have noted the buses who have submitted their stage carriage permits. Rectified list contain 196. The DTO and Secretary RTA Kamrup Metro further stated that till 7/6/2024, around 98 numbers of buses are yet to be rerouted as per the results of the lottery conducted on 5/4/2024, as the owners had not submitted the original stage carriage permits. They wanted us to surrender our permits. We refused. They have noted that about 98 has refused. They had not submitted. Then next page. The next page 218, serial 2. With regard to the renewal of stage carriage permit, it was decided by the RTA board Kamrup Metro that from now onwards, the renewal of stage carriage permit shall remain effective for a period of 6 months while adhering to the provisions of the MB Act 1988. So they limited it up to 6 months, and thereafter only 6 months basis, but law doesn't provide for that. And then 219 again, Lordship will see. Serial 5. The ACT Assam and DTO Secretary RTA Kamrup Metro placed the matter of modification of electric vehicle e-buses agreement signed between ASTC and the 2 private companies. The DTO and Secretary RTA Kamrup Metro suggested the inclusion of a disciplinary clause to that agreement after the end of tenure of the existing agreement, so that necessary actions could be carried out against the traffic rule violators who are managing and operating the e-buses, the 2 private companies drivers and conductors. They have not disclosed the names of these two, but they have, ASTC has entered into agreement. ASTC is not running the buses. Two private companies are interested, they have taken over. And to see that they can be controlled, they wanted some changes in the agreement. And therefore, they wanted that disciplinary clause. Necessary actions could be carried out against the traffic rule violators who are operating the e-buses, the two private companies, drivers and conductors. Therefore, they are acting at the behest of some other persons to accommodate some other persons with some extraneous considerations. Well, the public participation is totally ruled out. They have not stated, and nowhere it was published that they have floated some tender process and all to select, asking for participation. Nothing. They have not been able to place it. Simply to give benefit to some other persons. This cannot be the policy of the government. In a welfare state, when the object of the whole law is, MB Act is to say that public-private partnership, you must follow the norms, give opportunity to the downtrodden person even, considering his financial position and all, to elevate his own position in the society. And here they are acting like this. And our statement at page 39 of the Kuntu petition, 7263, we have stated, paragraph 35, my lord. Paragraph 35, my lord. Read petition number 7263. It is humbly submitted that the introduction of electric buses appear to benefit a select few entities who have been favored with exclusive operational rights to the exclusion and detriment of a large number of existing private bus owners, including the petitioners. Such an action is discriminatory, arbitrary, and violative of Article 14 of the Constitution of India, as it creates an unreasonable classification between similarly situated operators without any intelligible differentia or rational basis. The respondent's decision, therefore, is not only impractical in the context of Guwahati's topography and climatic realities, but also disproportionate and contrary to the public interest. It is liable to be struck down as arbitrary, discriminatory, and violative of the petitioner's constitutional and statutory rights. They have not replied to this.
No reply.
No reply. Right? We have stated about our economic position also in paragraph 37, 40. That we are subjected to penury gradually. Therefore, in my respectful submissions, the action of the authority is not only arbitrary, but also malafide. It is malicious as per law and also in fact. Law doesn't permit them to act in such arbitrary manner without invoking chapter 6. If it was at all there, and they do not have, the RTA board do not have the authority. The government has not done anything here. No such direction, nothing. The cabinet decision that was placed, once more Lordship will look into it. I will just place it. What the cabinet decision says, they have brought in it, I suppose, in their affidavit itself. Yes. Yes.
In which one, which case?
6117.
6117 ballot. That affidavit in opposition submitted by the authorities.
132 page.
132 page number.
132.
132. Yes.
That's a minute of the cabinet,
Yes.
28/2021.
Yes. It has not in any way converted into a decision of the government. No notification as such has been issued. Had there been so, probably it would have been annexed to this. It is a minutes recorded and kept in file. Lordship will appreciate that such a decision cannot at all be considered to be a direction or order of the to decision asil na car decision asil huh? Anicho na Vasit Singh eto ana nai Vasitra Singh, yes. The press court decision in Vasitra Singh, it is very clear.
Pachittar.
Vasitra. It is very clear that if it is kept in file, a decision taken but not implemented, then it
Not
has
communicated.
not communicated. Even no notification issued to that. What it says, my lord, kindly see.
Yeah, 1963. Yes.
1963, AR 1966 Supreme Court,
SC 390.
394.
390.
393, my lord, sorry.
95.
Oh, लिख दिया ना? Good. After detailed deliberation, well, what it says, subject, additional item number 11, my lord, Transport Department on this minutes, they say, subject procurement of 200 electric buses for operation in Greater Gauhati city and suburban areas, and creation of required infrastructure for operation of this fleet. Kindly note this, my lord, it doesn't say only in the city buses, only in the Gauhati city and the suburban areas. Also in suburban areas. Now, creation of infrastructure for that purpose. After detailed deliberations, Cabinet approved the proposal with following directions. 100 CNG operated buses for plying within the Gauhati Metro be procured with Gauhati Smart City Limited Fund and operated through Assam State Transport Corporation in Greater Gauhati area on revenue sharing basis between GSCL and ASTC. But in fact, now ASTC is not doing it. It appears that they are doing to private companies are involved there. Budgetary provisions for required fund through state budget in current financial year for creation of required infrastructure, including charging section, etc. by ASTC. To make the metropolitan city free from carbon emissions, ASTC shall stop running petrol diesel buses within the city area first. The department was also directed to explore the possibilities to stop plying of private vehicles buses within the city area in a phased manner. So it doesn't say that all buses should be stopped right from this date. It doesn't say stop running, but it says categorically that the metropolitan city free from carbon emissions, ASTC shall stop running petrol, diesel buses within the city areas first. They were stopped. They were stopped, not the other. In other cases, they said the department was also directed to explore the possibilities to stop plying of private vehicles, buses within the city area in a phased manner. Well, fine, if we take it as an advisory, in that case also, a notification ought to have been issued. Scheme ought to
You
have
are
been
submitting that pursuant to this MOM, there is no notification. So it has not been translated in the form of an order,
Order. It has not been translated.
taken the
into-
shape of an order.
Yes.
So it cannot be
It
implemented.
cannot be implemented.
You cannot link this with the
What
RTA
you-
decision.
Never. And they have not also referred to this. They have not referred to this also. Even if referred to, this is wrong. There cannot be. It has no legal force unless it is implemented properly in accordance with law. Therefore, my responsible submission is, my lord, whole action is wholly without jurisdiction. They acted without authority and with malice in law and vitiated by malice in fact too. Hence, should be interfered, and this designation being totally illegal, it will not prevail. Their decision cannot sustain the scrutiny of law. It should be interfered with, and it should be replaced with the original position. And if they want to go ahead with it, law is always there. They need no advice from us how to go about. They have a strong team to suggest them in law. Therefore, my sole submission, this thing should be reversed back, declaring the whole process as illegal. And for the damage meanwhile done, they should compensate us. I leave it to your lordship, my lord, just to consider. Because the families have suffered greatly, no doubt about it. Subject
Yes.
to what they say. Oblige. Sorry, judgment, my lord, I would like to refer to.
Yes.
State of West Bengal versus and others versus SK Nurul Amin. Lordship file may have a copy. Even this interpretation apex court has
It's not there.
Not there.
On what point of law are you citing this?
Even here, the court has said that even under section 72, you cannot change the route. You can add, modify conditions, but that condition change can only lead to the change of the length of the route, not the route itself. You cannot change.
What is the citation?
Citation is 2010-11 SCC 182. State of West Bengal versus SK Nurul Amin. The High Court of Calcutta.
Which
has,
paragraph?
Paragraph 8, my lord.
Para 8.
Yes. What is prohibited by the proviso to subsection 1 of section 72 is granting of a permit in respect of any route or area not specified in the application. The said proviso does not prohibit curtailment in regard to portion of the route applied for any valid reason. In fact, subsection 1 specifically authorizes the authority to grant the stage carriage permit with such modifications as it deems fit. Curtailment of a route would be a modification as contemplated under subsection 1. We may clarify this by an illustration where the application is made for grant of permit in regard to a route A to D through points B and C. If the grant is made for the route A to C through B, excluding the last portion C to D, it will be a modification which is contemplated and provided for under subsection 1 of section 72 of the Act. On the other hand, if the grant is made in regard to route E to F or in regard to route A to E, the grant will be in regard to route not specified in the application, and consequently the permit will be violative of the proviso to subsection 1 of section 72 of the Act. In this case 9, route applied for was Dhulian Bazar to Kolkata via Raghunathganj and Basarat in one case, and Raghunathganj to Kolkata via Basarat in other case. Permits were granted for Dhulian Bazar to Basarat and Raghunathganj to Basarat, excluding the portion from Basarat to Kolkata. Such curtailment was a modification which was permitted and authorized by section 72(1) of the Act. The division bench of the High Court was not therefore justified in holding that the grant of a permit for a route with any curtailment would be a violation of Section 72(1) of the Act. The next question whether the authority was justified in curtailing the route and granting the permits only up to Basarat, thereby deleting the last leg of the route from Basarat to Kolkata. Though no reason was given in the communications of the authority about the grant of permits, the resolutions of the authority gave the reason that the curtailment was necessitated due to need of the restrict entry of new passengers transport vehicles into Kolkata on account of heavy traffic congestions and increasing vehicular pollution. The respondent contended that the said reason was not a valid reason, and during the pendency of these matters, long after curtailment of route in this case, several permanent stage carriers permits were granted on various inter-regional routes, all up to Kolkata without any curtailment. So court says that yes, only length can be cut short, modified, not the route.
That would be conforming to 72(1).
One.
Now, if you alter the route at all, that is not permitted in the
Not
72.
permitted. You can-
Example has been cited, one illustration.
You can last leg, I applied from here to, say, suppose Mirza. They said no, we'll grant it up to Azara. That can be done. Or once granted, that's subsequently modified, limited to Azara, but they cannot change the route as well. The purpose of 72(1), and this is what 72(2)(22). A, B, that says. Therefore, it cannot be, their plea that we are authorized to act under 72 is not permissible. And they on their own have said that 103 is invoked because they are to cancel our existing permits. That only permissible under 103 of the chapter 6.
Important to be one.
And they may argue, or they have argued earlier also, that
2130.
They were also granted opportunity either to convert it to CNG or to go for e-bus. So opportunity was given, not that they were totally barred, but they were given options. Whether a burden of that nature, which is impractical for us to fulfill, can be considered to be a fair opportunity to us. Apex Court said no. 2004, 6 SCC 440. Three judgments, Captain Subhay Singh and others versus Lieutenant Governor of Delhi and others. This is regarding their pass and all.
Paragraph?
29 and 30 I will refer to, my lord. They have referred to constitutional decision, paragraph 29, Lord Supreme Court. In Anjum MH Ghaswala, a constitution bench of this court reaffirmed the general rule that when a statute vests certain power in an authority to be exercised in a particular manner, then the said authority has to exercise it only in the manner provided in the statute itself.
This is Nazir Ahmed,
Yes, Nazir Ahmed. So, my lord,
36 PC.
yes,
Same language.
same language, exactly same language, my lord. Then, question is, when there is a particular procedure prescribed under the law, how can they go against
Alter that prescription.
alter the
Either you act in the
In
prescription or you do not act at all.
No,
Other means are necessarily forbidden. That is the expression used
exactly.
in Nazir Ahmed.
Yes, taken from Taylor versus Taylor, that. Therefore, once the manners are prescribed, how to go about, you either do in that way or don't do. But you cannot mingle and take an action in violation of those. Then, 30 also I would like to just refer, the contention of the respondents is that the power to enforce the binding nature of the concessional passes issued by the DTC on the private stage carriage operators can be spelled from the provisions of section 67(1)(d) of the Act. In our view, such a power cannot be subsumed under the powers the state government to fix fares and freights for stage carriages having regard to the desirability of preventing uneconomic competition among holders of permits. Permit conditions, condition 13 merely stipulates that the permit holder shall ensure that concessional passes issued to various sections authorized for these buses shall be honored. The authorization has to come from STA. In other words, only concessional passes which are authorized by STA would be binding on the operators. We see no power in section 67(1)(d) of the Act or otherwise by which a concessional pass issued by the DTC could be made binding upon private stage carriage operators, particularly when there was no such conditions imposed in the permit issued. Hence, we are of the view that paragraph 3b of the impugned notification is clearly ultra vires the power of the state government under section 67 of the Act and therefore liable to be quashed and set aside. They wanted that the passes should be applied and followed by all the buses. The DTC issued some passes to many persons monthly or yearly wise. That the private buses, they refused to accept it. In that conditions, the dispute arose and notification was quashed. So for the private players are concerned. How did I say it? What is it? What question is it?
Even if he was even
Yeah, my lordship may also read 31 paragraph. Sorry, my lord.
31.
31. The appellant then that the condition imposed upon the appellants for honoring the DTC passes is nothing but a covert attempt to subsidize the losses being incurred by DTC. Even if we assume that the losses are not on account of mismanagement or inefficiency of DTC and are really attributable to the so-called honoring of its social obligations, we see no warrant or justification under the provisions of the statute as they stand for transferring this assumed responsibility to competing transport operators. If the state authorities are of the view that the fare structures should be identical for all operators including DTC, we see no justification for this indirect method of passing on the cost to the appellant operators. In that case, the court says that you cannot pass on your responsibility, your obligations to the other party. It is for the government. So the private operators cannot be burdened. Social obligation, they say in the first place, 32. We are unable to accept that all concessional passes issued are necessarily in the discharge of social obligations, as claimed. A perusal of the operational statistics of DTC, which is placed on record as Annexure P9 to the writ petition filed before the High Court, page so and so, justified the contention of the appellants. From the operational statistics, we notice that nearly 48% of the persons traveling in the DTC buses were pass holders in April 1998. And this figure has gone up to about 68% in November 1999. While it may be possible to say that granting of concessional passes to war widows and their dependents, disabled persons, freedom fighters, and such categories may be in the discharge of social obligations, it would not hold true that true with regard to the large number of other holders of concessional passes. In the writ petition before the High Court, the appellants pointed out that destination passes, general passes, and all route passes are nothing but smart exercise just designed to catch captive commuters. These passes are really intended to collect advance fares, which should have commuters the trouble of frequently going to the office of the operators for paying for their passes by offering a marginal concessions. In other words, a large amount of the fare gets collected much in advance, and what DTC has to forego is only a small amount
This
designed
may
to
not be
cut down.
necessary. The principles you have already.
Yes, so the court ultimately says you cannot transfer your responsibility to the private respondent. They are not bound to do it. So social responsibility, welfare, it is your duty. You are to do it. And you cannot pass on your responsibility in any way to the private players. That is what the apex court ultimately said.
Corona and the other perimeter.
Oh. Edith got a mark coaching. There is one more decision of our court, division bench decision. It is reported in AIR 1973, Gauhati 1. (1972) SCC Online, Gauhati 40. That is Manik Chandra Das versus State of Assam and others. Division bench of Honorable Justice P.K. Goswami, Chief Justice, and Baharul Islam, J. It is regarding to the Act, MB Act, before amendment. But these provisions are almost perimeter here in the new Act also. Paragraph, I will take your lordship to paragraph 13. From the foregoing provisions, it is clear.
Paragraph 13.
13, 1-3.
Mr. Mahanta, we have to write quite clearly. There is a meeting at 1:05.
Yes.
And second half would have we'll sit, but a bit late.
Yes.
But we'll try to finish this matter
Yes.
today.
No, my lord, what instruction now? They have filed affidavit, they know everything. What instruction they may get it if possible by phone?
That is not the pleading
But
case.
that-
There is
that-
no pleading as
No,
such.
that we have asked. And we can ask. Was there any tender process before you give such a big contract to somebody, two players?
Their admission,
And you should be very fair in disclosing to the court as an officer of the court.
exactly.
Tomorrow, nobody has seen tomorrow. Have you seen tomorrow?
Exactly.
We have not seen tomorrow. Next week, this court is not there, so we'll have to finish it today.
Yes, let them get the instructions by 2. No, or lordship will sit little later
Okay.
offline.
You were citing 73, AI 73, Gauhati 1.
Yes, yeah, 73 going to 1.
Manik Chandra Das. What is the ratio?
Here, my lord, the court has said that
Which paragraph?
13, I will refer to paragraph 13.
13.
Yes. Having discussed the provisions of 68, section 68, and other 68, thoroughly all provisions, court has said like this. From the foregoing provisions, it is clear that an elaborate procedure has been made with regard to the nationalization of a route to be served by state transport undertakings. Under section 68C, It was necessary for the Road Transport Corporation in this case to form an opinion with regard to matters contained therein, where it is necessary in the public interest that road transport vehicles in general or any particular class of such vehicle should be run and operated by the corporation, and whether to the exclusion, complete or partial, of other persons or otherwise. Once that opinion is formed by the corporation, it is mandatory for
It
it,
is obligatory.
yes, it is obligatory for it to prepare a scheme giving the necessary particulars mentioned in this section and publish the same as provided for under the law. Two things are therefore necessary under section 68C. Firstly, formation of an opinion with regard to the necessity of operating a state transport undertaking in the public interest to the exclusion, complete or partial, of other permit holders, etc. And secondly, once the opinion is formed and it is decided to operate the road transport service, the corporation has to prepare a scheme and publish the same. The procedure laid down under section 68C does not contemplate an informality of any kind in a matter like this, affecting the rights and financial interest of the existing permit holders and also public interest in general. We should have therefore expected the corporation to comply with section 68C in first arriving at a decision about nationalization of this route, and next to publish the scheme with all particulars so that interested parties may submit their objections to the same. After hearing which, the scheme may be approved either in toto or by necessary modification. The entire chapter deals with nationalization of routes by state transport undertaking and necessarily involves ouster of existing permit holders affecting their rights. It is therefore necessary that the procedure laid down under section 68C must be complied with before any scheme can be held to be valid under the law. We are clearly of the opinion in this case that the Road Transport Corporation did not at all apply its mind to the particular scheme which was published by the fifth respondent on 8 March 1972. The fifth respondent therefore had no jurisdiction to publish the scheme, and the scheme being not in conformity with section 60C is invalid and ultra vires. A scheme so and so is therefore quashed. So, my lord, here in the old law it is 68C, and here now it is chapter 6, 72. No, 71, very 91, 99. Nine. So under chapter 6, 98, 99, preparation and publication of proposal, that objections 100, and then 101, 102, 103, complete provisions are made up to 108. Old rector of Illinois. 58. So in the old law, my lord, before amendment, this was chapter 4A, the old act, the 1939 act. And chapter 4A, here 68C speaks about preparation and publication of a scheme of road transport service of a state transport undertaking. Where any state transport undertaking is of opinion that for the purpose of providing an efficient, adequate, economical, and properly coordinated road transport service. It is necessary in the public interest that road transport services in general or any particular class of such service in relation to any area or route or portion thereof should be run and operated by the state transport undertaking, whether to the exclusion, complete or partial of other persons or otherwise. The state transport undertaking may prepare a scheme giving particulars of the nature of the services proposed to be rendered, the area or route proposed to be covered, and such other particulars respecting thereto as may be prescribed, and shall cause every such scheme to be published in the official gazette and also in such manner, other manner as the state government may direct. So interpreting this, our court has held that this is to be completed because the same principle that if certain work is to be done by following certain manner, it must be done in that manner or not at all. It would be,
Why is it not doing it? Where I took, tell you a certificate.
in that, malad, আৰু আনিছিলো আমাৰ হেৰি কেছতো আছিলে কিন্তু আৰু এটা আনিছিলো মই হেৰিত to buttress that point, Malad, I would like to refer to one more decision of the apex court, 3 judges bench, 19, oh sorry, here it is, 1963 SCC online, SC 23, AIR 1964 Supreme Court 358. State of Uttar Pradesh versus Singhara Singh and others. Though it is in respect of a criminal case regarding 164 statement, the apex court has said, paragraph 8, my lord. The rule adopted in Taylor versus Taylor is well recognized and is founded on sound principle. Its result is that if a statute has conferred a power to do an act and has laid down the method in which that power has to be exercised, it necessarily prohibits the doing of the act in any other manner than that which has been prescribed. To that extent, I rely on this. And here, since a prescribed procedure is there already in law, they could not have acted contrary to it on the pretext of modification of the clauses or the terms of the conditions of the permit under section 72.
Yes.
This principle, Lordship, is a word that referred to in very many decisions. It was so administrative action also. I will one more decision on the same very point, my lord. In administrative action, Bhavnagar University versus Palitana.
Which point? That you need to follow the prescription of law?
Yes, yes.
Not required. I think these are enough.
Lordship may take note of if
Yes.
necessary. My lord,
If principle is the same, we are not going to
yes,
repeat, not
2003
required.
to SCC 111, paragraph 40. That's it. In administrative work also. Within the four corners of the rules, they must act. This is what the law is. Anything or no? So, my lord, my respectful submission, therefore, they could not have acted otherwise than the prescribed manner of life.
Yes, Mr. Note. You appear for whom? All the respondents.
Lord, I record my name for 2, 3, and 4. My friend is Proba. The regional transport authority is represented by the DC. But
The Deputy Commissioner perhaps is the ex-officio chairperson of the RTA.
he is the chairperson of the RTA. The RTA is a party here, 2, 3. Follow me kindly.
Which petition you would like to refer?
One of the 6117 has been appealed.
6?
6117.
Okay, you are referring that.
That is enough.
Hmm.
That is enough. Logic, kindly come to the prayer, made in the declaration. And some paragraphs, I will change the logic. What is the projected phase of the petitioner, madam? In fact, what they have projected. Prayer logic will find at page 27.
Yes.
Basically, they have challenged the minutes of the RTA meeting dated 5/4/2025. They have said in the prayer that in the premises opposite so and so, a rule calling upon the respondents to show cause as to why a writ of mandamus should not be issued, directed the respondent authorities to recall, rescind, cancel, and or forbear from giving effect to the impugned resolution number 2 of the RTA meeting dated 5/4/2025, and further to direct the respondents to renew the permits of the buses for this statutory period and to declare that the renewal of permits in route number 23 and 36 for a period of 6 months at almost the same rate prescribed for 5 years permit is arbitrary, illegal, and liable to be interfered with. So this is their basic all of the prayer. Here, 2 prayers lots you will find. One is resolution number 2 of the minutes of meeting dated 5/4/2025, number 1. And number 2, because they have said that 6 months renewal you are doing, but you are taking the higher fee, the same fee you are taking, but you are renewing for 6 months. To declare that the renewal of permits in route number 36 and 23 and 36 for a period of 6 months at almost the same rate prescribed for 5 years. That is the second clause. Then they said that it is further prayed that this honorable court be pleased to direct the respondent authorities to allow the city buses of the petitioners to ply in their designated route number 23 and 36 and not to out their vehicle from the same routes. And it is also prayed that a writ of certiorari is issued setting aside and quashing the impugned resolution number 2 of the meeting dated 5/4/2025. So
Yes.
these are the prayers. And while challenging the resolution, kindly see what exactly they are agreed as regard the resolution of 5/4/2025. Kindly come to para 9. 2-3 paragraphs I'll like to refer. Then I'll just note to the affidavit. Paragraph 9 at page 12.
Page 12.
12. The petitioner has stated that in a meeting dated 5/4/2025, the respondent authorities have adopted an arbitrary and illegal resolution number 2, wherein it has been decided that the validity of permit of buses operating on route number 23 and route number 36 shall not be extended beyond 31st of December 2025. Thereafter, in furtherance of the above mentioned resolution number 2, another meeting with the members of RTO was held on 5/7/2025, wherein a resolution was adopted that only CNG compliant buses or electric buses would ply on route number 23 and 36, thereby completely removing the private city buses. This lordship may kindly mark. They have projected that we have to remove the private city buses. That kindly mark. I'll have a submission of that. And of the petitioner association operating on route number 23 and route number 36. The office bearers of the petitioner association had attended the aforesaid meetings as invitee, and they vehemently objected to the said resolution being totally detrimental to the interest of the bus owners. However, objections of the petitioner did not sustain, and as a result, the authority is banned upon removing the city buses under the petitioner association from route number 23 and 36. Then kindly see para 11. Para 10 just said that decision of 5725 is a prejudicial decision to them. They have filed a representation to that. Para 11 kindly come here. The petitioners must respectfully state that the respondent authorities have stated in their minors dated 5425 that the validity of permits of the buses operating in route number 23 and 36 must not extend beyond 31st of December 2025, as the same would be considered as green routes. It is quite ironic as to how the injunction of only 100 buses in the street of Gauhati would turn the routes into green routes, even though 11 lakhs non-electric vehicle of Gauhati would ply on the same. In that way, they have said that therefore, off-roading of 167 city buses and injecting 100 electric buses would make an inconsequential and immaterial difference when approximately 11 lakh vehicles flying on the same route would be of petrol diesel operated. Thus, the removal of these buses from route number 23 and 36 is highly arbitrary and unjust and seems to be done only to cater some big private players, as the government do not run the electric buses themselves. That is the projected case. And in paragraph 14, they have expressed some difficulty as regard having CNG, because they were given an option that you convert your buses to CNG or electric, then you can also buy. They were given the option. They said that two problems. One is financially, they have the financial difficulty because a lot of money is involved in that. And secondly, CNG depots are not available. That is their objection. Then para 20, they allege that Article 14 and Article 19 violation. That is basically this is the case. But in fact, logic, kindly take out my affidavit, the affidavit in opposition file. And they said in para 29 that they have some loans in bank and all. Ultimately, it is
Those would be in the factual realm.
logic. They basically what they said that if they are stopped in running the vehicle in that particular route, they will be economically affected. That is what they are. But my responsible submission is on three of the points. Number one is that it is a policy decision, and the policy decision, my respectful submission that the judicial review in the policy decision is very limited. That is number one. Number two, my respectful submission is that petitioner has no fundamental right. Although they have alleged that Article 19, 14 and 19 has been violated, my humble submission is they have no fundamental right to run a bus on a particular route. We are not stopping them from running the bus, flying the bus. We are not stopping their business. Only we are regulating that in this particular route you cannot. If you are going ahead with this, that is not our resolution. And third is they have challenged the jurisdiction of RTA. Whether RTA can be on.
That is one point which we would like you to address.
Logic. These are the 3 points.
Yes.
Logically, kindly take our affidavit. The affidavit starts at page 118.
Yes, we have got.
Logic. Kindly come to page 135. This is the RTA board meeting held on 20th of December 2024.
Page 135.
135 it starts, annexure C.
Hmm.
But on 20th of December 2024, the RTA meeting has taken a decision. Kindly come to relevant portion below at decision resolution number 3, 137, page 137. So this decision was already, but this was not only the suddenly taken in the month of April 2025. 137, 3, Green City Bus Goods. The meeting has decided that as suggested by the MD STC and recommended by the DCP Traffic, Gauhati, the Honorable Chairman RTA Kamrup has directed the DTO Secretary RTA Kamrup Metro to explore opportunities in gradually phasing out the diesel operated city buses flying on city bus route number 23, Khanapara to so and route number 36, Vasishta to so that by January 2026, only electric buses could fly on these two routes, aligning with sustainable and eco-friendly transportation objectives. It was taken a long time.
But from where did the decision originate? Did it originate from the state?
Look,
Here, we did not have an opportunity to look at this before. It also says that suggestion is given by the managing director of STC.
and recommended by the DCP Traffic and
No, these are not state. We are on the law governing the field. Law gives you the power, but it has to be exercised in the manner prescribed. Power is vested on a particular authority. That authority, origins of the decision-making process does not appear to come from that authority.
Under section 68
Of the Motor Vehicles Act.
Yes.
68.
60. But this provision is under chapter 4 and that is control of transport vehicles. And 68 provides transport authorities.
68.
Logic.
68 is
68(1).
transport authorities.
Transport authorities. Logic. Two types of authorities are defined here. The state government shall, by notification in the official gazette, constitute for the state a state transport authority to exercise and discharge the powers and functions specified in subsection 3, and shall in like manner constitute regional transport authorities to exercise and discharge throughout such areas as may be specified in the notification in respect of each regional transport authority, powers and functions conferred by or under this chapter on such authorities. So, Manoj, here we are concerned with the RTA. RTA.
There is no dispute to the constitution of the RTA. There is no dispute.
National Association, they are attending the meetings, Manoj. They are all along, they are in the process.
Not now, sometimes.
All along, even in this.
No, their attendance or not in lack of attendance may not be the sole factor. We are only concerned with the powers whom is it vested with.
The RTA for that particular area, the Gauhati district, the RTA of the Gauhati Kamrup Metro, and the state transport authority for the state. So RTA is constituted. RTA is there. There is no dispute to that. So whatever power is under this act, these are the two authorities they can exercise. Kindly come to 68(3).
68(3), yes.
68(3). The state government of this state.
But Senior Council has referred to 67.
Lot. Yes, 67 will come.
67, power of the state government to control road transport.
Yes.
And the specific reference has been made to 67(3).
Logic.
67(3) would be the relevant power which has been given to the state government to modify, permit and make schemes. Protection of many other things.
Ultimately, the state transport authority and every regional transport authority shall give effect to any direction issued under section 67, and the state transport authority shall subject to such directions and save as otherwise provided by or under this act exercise and discharge throughout the state the following powers and functions, namely, what my respectful submission is, under 68(3), the state transport authority and the regional transport authority, they are the authority through whom the government will discharge their function. They act. Because the 68(3), it starts with the state transport authority has logic.
Yes, yes.
Logic is the state transport authority and every regional transport authority shall give effect to any directions issued under section 67, and the state transport authority is also. So under 67, but they are the ultimate authority.
No. See, Mr. Nath,
Logic.
since you are reading subsection 3, the creation of the powers of the state to create state transport authority and regional transport authority is not in doubt. 68 gives the powers to have transport authorities. You create transport authority, RT is there.
Logic.
Now 3 says state transport authority or every regional transport authority shall give effect to any directions issued under 67. So we want to know what is the direction under 67, if there is any.
Right.
First origin comes as a suggestion from the MD-ASTC.
In fact, the green city bus route, it's a concept. It is coming not. Although the petitioner has challenged that in the month of April 2025, the resolution number 2 has taken the decision, but I am placing it before Lordship that this is an idea which originates long back.
But show us the idea that matter ends there. It originated in the state. It has been implemented through RT, no problem.
Yes. Page 132 of the FAQ.
132.
130. Yes, it's not. Kindly come to, this is the cabinet decision, kindly come to Roman 3. This was on 20th of August 2021. To make the metropolitan city free from carbon emission, ASTC shall stop running petrol diesel buses within the city area first. The department was also directed to explore the possibilities to stop flying of private vehicles buses within the city area in a phased manner. So that idea originates long back. That in a phased manner they are going ahead.
Which part did you read?
Roman 3. Page 132, Roman 3.
But this had, the idea was mooted by the cabinet in its meeting held on 20th of August 2021. And these are subsequent actions taken pursuant as offshoots, not offshoots, consequential action.
Consequential actions. So they are going ahead.
That is your projection.
They are going ahead in a
Phase manner.
In fact, at page 133, kindly see. Phasing out of diesel city buses. It is little bit not clear, but the last one, serial number eight,
Yes,
serial number 8.
yes,
Phasing out of the diesel city buses, MDASTC to submit a proposal with details of the phase-wise introduction of CNG EV buses with time, with timeline, so that necessary steps. So this was the minutes of the review meeting of the State Transport Corporation held in the chamber of this secretary. In the cabinet meeting, the minutes of the cabinet, what you will see, a committee has been constituted for guiding at serial number 14.
yes,
So the idea originates from there.
yes.
Next page, it continues to next page. Steps can be taken by RTA for phasing out of the diesel operated buses as per EV policy. Next page.
Yes.
It continues to page 134.
Yes,
Then in the course of time, the December 2024 decision which I have placed, that at page 137 comes.
yes.
No.
Starts at 135, relevant at 137. That you have already shown.
That I have shown.
Hmm.
That I have shown. And at that point of time, that decision was to explore opportunities in gradually phasing out the diesel operator. That is to only to explore. Then comes 5/4/2025 at page 140 and 141.
141.
140. This is impute. The RTA board in its meeting held on 5/4/2025 has taken many decisions regulating the vehicles, logical C, all the topics, logical C, implementation plan for prohibition of e-rickshaw on 56 main road of Gauhati. Then second 144. This is relevant for our purpose. So while it is in their mind to explore, while it is in their mind to explore the mechanism, how to phase out the diesel operated vehicles from the city, they have discussed.
Here in this 5425 minutes, where is the relevant discussion?
Discussion at 144.
144. Renewal of stage carriage. This.
The 144.
The second agenda, perhaps.
Yes. Topic is designation of city bus route. Topic is designation of city bus routes number 23 and 36 as green routes and renewal of stage carrier permit of diesel operated buses flying in Kamrup Metro. That is the topic. On that topic, the discussion has been held. Kindly see that the Act of Assam and the DTO and Secretary RTA Kamrup Metro informed that as per resolution number 10 of the RTA board meeting held on 20/12/2024, the MTAG has submitted an affidavit seeking withdrawal of the Honorable High Court. So this follows a decision to allow the remaining 46 buses out of the original 196 involved in the case to operate in their previous stage carriage permits. The DTO and Secretary RTA Kamrup Metro further informed that approximately 169 diesel operated buses, including 19 out of 46 aforementioned buses, are currently flying on city bus route number 23 and 36. These routes have been designated as green route as per RTA board resolution. In this regard, RTA board resolved that the renewal of stage carrier permit of these buses shall be granted on a 6-month basis, similar to the process of diesel operated buses on other routes, However, the validity of permits of buses operating on route number 26 and 36 must not be extended beyond 31st of December 2025. The DTO and Secretary RTA Kamrup Metro shall ensure strict compliance with the deadline. The DTO and Secretary RTA Kamrup Metro shall immediately arrange a meeting with the MTAG to inform them of this decision. The objective is to explore alternative route for their buses post 2025. The bus owners may also be encouraged to switch to CNG or electric buses in order to continue operation on route 23 and 36 beyond 31st of December 2025. In the month of April, one of the decision was taken that we have to encourage them to have to shift to CNG or electric bus. And they addressing the issue of non-reciprocal permit fee. This is the I'm referring because this is one of their prayer. Addressing the issue of non-reciprocal permit fees, where a 6-month stays carrier permit costs 2150, while a 5-year permit costs only 3150. The Honorable Chairman directed the DTO Secretary Kamrup Metro to report this anomaly to the Commissioner of Transport in order to ensure financial fairness for the buses. So this was taken care of. Possibly it is yes. This is in their knowledge, and if that is the grievance, it is under consideration of the authority. Ultimately, that is not a problem for us. That will be considered.
Which will be considered?
The last paragraph, Roman 3. They said addressing the issue of non-reciprocal permit fees, because for 5-year 3150 and for 6 months 2150. They said it is on the higher side because of the system generated thing, that at their level, they could not do that. Ultimately, they have taken up the matter with the NIC, and that some decision they will take. That is not a problem. This is one of the prayers they have in the repetition. That is why I am referring. And in the last column, if logic kindly takes up 142, the last column in the every minus they have mentioned the stakeholders. For this resolution number 2, stakeholder, they have considered that DTO and Secretary RTA Kamrup Metro and MTAG Gauhati. MTAG is the petitioner. So for implementation of this decision, MTAG is a stakeholder. Because the decision which now we are picking up the decision with them, and we are encouraging them to come up. If you want to apply here, please change. Come to electric or CNG, or otherwise they have also taking a decision that for enrouting of the buses to other routes. We are not touching their livelihood. Then kindly come to the annexure E 153.
153.
153.
This is 57.
57/2025. Lot. 153. Kindly see permit validity registration restriction. The attendees are
Yes.
Attendees are list of representatives from MTAG and city bus owners of 23 and 36 are also there. And the RTA board members are there. Then they discuss the permit validity restriction. The validity of permits for buses operating on route number 23 and route number 36 shall not extend beyond 31st of December.
Where are you reading?
I'm reading first. Logic will find that welcome and objective.
Yes. Permit validity.
Yes, then permit validity.
Yes.
Validity of permit for buses operating on route number 23 and route number 36 shall not extend beyond 31st of December 2025. These routes will be designated as green routes effective from January 2026. And the objective of this meeting is to highlight the resolution of 5/4/2025 to the participants and the dignitaries. And then role of DTO and Secretary RTA to ensure strict compliance with the permit deadlines and oversee the transition process. See further elaborated the key objectives of the meeting to create awareness about the RTA board resolution to explore alternative routes for affected buses post 2025 and to encourage the conversion of CNG or electric buses for continued operation on Route 2023 and Route 36 beyond the stipulated deadline. Then kindly see below. Serial number, next page, 154, serial number 3, towards bottom.
Yes.
Interactive session with MTAG and city bus owners. An open mic interaction session was organized to clarify queries and concerns. Several bus owners and association members raised concern regarding the cost of conversion from diesel to CNG and associated operating expenses. In response, Srimati So-and-so requested all the stakeholders to submit written petition to the office of the DTO and Secretary RTA Kamrup. So their concern and suggestions could be presented before the RTA board for further consideration. Then the meeting concluded, and the list of attendance sheet is there. Lot of bus owners, they attended. It continued up to from 156 to 160, it continued. Page 161 is a communication to the Commissioner of Transport regarding the issue of non-reciprocal permit fees, which they are raising. This has been highlighted to the authority and it has been taken up with the authority. They have also, there are some processes going on. That is on already it was taken up in the month of April 2025. Kindly come to page 162. After the meeting, they attended the meeting on 5/7. They have given us this letter. The petitioner, they said, I am writing to inform you that 162.
Just a minute. One 62 is their letter.
Is their letter. After attending the meeting, they have given one.
Yes, Mr.
I'm
Mr. Mahanta has referred to this letter. 5725.
5725. I'm writing to inform you that the RTA board meeting held on 8/4/2025 proposal to remove our diesel operated mini-city buses from route number 23 and 36 due to introduction of e-buses at Gauhati city. Consequently, the RTA authority directed us to convert our diesel operated city buses to CNG operated buses for route number 23 and 36 before 31/12/2025. After consulting with our route bus owner members in a meeting held on 25/6/2025 at MTAG office, VIP road so and so. After discussion with the respective bus owners, it was decided that accepting the RTA board's proposal dated 8/4/2025 is not possible for us due to present financial condition of the owner members. Two things, Lordship may kindly note in this letter. On behalf of all MTAG members, I so and so hereby unable to accept their proposal. Two submissions I have, kindly. They are aware of our decision. Because our meeting was on 5/4/25. They held a meeting amongst themselves on 25/6/2025. And according in that meeting, they have taken a decision. And subsequently, their only grievance is that financial condition at present, financial conditions is not good. That is their grievance. They cannot convert because they said that it is not possible for us due to present financial condition of the owner members.
No, that is okay. In the representation, submission of representative did not consult Mr. Mahanta. Now Mr. Mahanta has raised legal issues.
But that is
We have to answer it.
Not till
And
that
this is
day.
the original proceeding.
Yes.
true. What I'm indicating on that basically they are objecting to what? I'm on two things, Lord. Lordship may kindly see, Lordship will examine the decision-making process and whether they have been prejudiced, whether any right has been violated, and whether they are all of a sudden out of the blue, whether they have been imposed. That you go up. That is not the case. Although the projection is that we have taken 200 buses and we have put the buses, throw them out. It is not the case. Right from the beginning, Malad, a request has been made to them that you please see, we are making it carbon free. So you just change it. Come up with that. With the change of time, Malad, you have to kindly come to page 169. Thereafter, this Malad is a resolution. It starts at page 168 on 5/8/2025.
On the page.
After 5/7/2025 meeting, this is 5/8/2025, 168.
Which page?
Page 168. It's
168. What is there?
This is the second RTA. Thereafter, the RTA board again held a meeting. This is the minus
58.
5/8.
25.
Logic. 5/8/25. Relevant, kindly come to next page. Relevant is 169.
169.
Topic is designation of city bus route number 23 and 36 as green route. After careful consideration of all previous resolutions taken in the RTA board relating to green route resolution, the meeting conducted with the MTAG and city bus owners dated 5/7/2025 and the memorandum submitted by the MTAG dated 5/7/2025. The RTA board approved the following directives. Green route resolution continuation. The RTA board affirms that it cannot reverse the earlier decision taken in its meeting held on 5/4/25 concerning the green route resolution for city bus route number 23 and 36, especially in view of upcoming introduction of another fleet of 100 number of so-and-so bus under PM E-bus Seva scheme expected to be operational under ASTC by January 2026. Then permit renewal for CNG fuel buses. Any bus owners currently operating on route 23 and 36 who opts to convert their vehicle to CNG from diesel shall be permitted to renew their stage carrier permits for their existing routes beyond 31/12/2025 or 31 December 2025. This option is always with them. Now, before coming to court, they are projecting themselves as a common man. They are bus owners.
But they're earning their livelihood by operating buses.
Option has been given to them, and this is not two options were given to them. In fact, we have said that you please come to electric or CNG, or we have taken 10 routes. We have given 10 routes. You go there. We have not said that you just stop their buses. You cannot run anymore. We have not said. Kindly come to next page. This is why this resolution is important. 170.
One 170. Next page.
Yes, in that meeting, along with the earlier decisions for which I have read, the Roman 4 alternative route for diesel fuel buses. The diesel fuel buses that fail to convert to CNG will be permitted to operate on routes 23 to 36 beyond the stipulated date. Will not be permitted to operate on route 23 to 30 or 36 beyond the stipulated date. The DTO and Secretary RTA Kamrul Factory is directed to allocate alternative route to such operators on first come, first served basis. Upon receiving a written undertaking from the concerned owner, consideration shall be given to hypothetical vehicle in the route reallocation process. Then DTO and Secretary RTA company shall convene a meeting with the concerned association and bus owners and submit the report for consideration in the next RTA board meeting. So alternative, that they have also thought of giving them alternative route. Well, this is the format of undertaking at page 181, totally fine. That I, so and so, the owner of municipality bus number so and so, route number 23, that I will be abide by the resolution number 2 of the RTA board meeting dated 5/4/25, and the order of the chairman RTA company Metro at the permit number 22 so and so must not extend beyond 31st of December 25. Therefore, I issue you that I shall not ply my diesel operated city bus number so and so in the existing 23, route number 23 from 1st of January 2026. And they have expressed that, ma'am, I kindly request you to renew my permit for 4 months for the last time, and thereafter, I would like to confirm that I shall change my existing route number 23 to new route number 34 during the next renewal of my stage carriage permit. Thereafter, on
Yes.
page 82, 182,
182.
182. On 13/10/2025, the RTA board meeting held, and the RTA board meeting discussed at page 183 the current status of diesel fueled city buses plying on route number 23 and 36. So by that time, the process has started. Many of them have come ahead, and they have enrouted their vehicle to other routes.
183, which one?
183 first Roman 1.
Yes.
Current status of diesel fuel city buses plying on route number 23 and 36. The DTO and Secretary RTA Kamrup Metro informed the RTA board that out of 158 number of diesel operated city buses which are plying on route number 23 and 36, 4 number of buses had already been enrouted and 32 numbers of applications had already submitted undertaking for route change prior to 1st of January 2026. So that process has already started. The alternative for arrangement has been made, and they have already started. The process has already started, and the position is as on today, that out of 158 or 167, because they said 167, here it is said 158. Only 50 or 50 buses are left. It may be less than 50, but notified take up as 50. Others have already gone. They have already gone to the new. As regard the alternative route, I have one more submission.
These 50 buses have not been allotted alternative routes.
They have been given the option.
They have not opted.
They have not chosen.
They have not come forward.
They have not come forward. They have not come forward. Possibly because of the pendency of the litigation, or they may have some other reasons. But the alternative pass, the alternative route allotment, that has been, that is on record in the repetition, the other repetition, 7263.
Hmm.
In the second 7263, if for a moment kindly takes up that petition.
That is before us.
Logic, page 87. Page 87 of that petition. These are the notices will have given to all of them.
80s.
Page 87, annexure 7 series.
87 is the communication of 21st of November. Page 87.
7263. Read petition 7263 in the other read petition.
Yes, other one.
Because at that point of time,
7-6-3 only. Page 87 is a communication dated 21st of November 2025.
yes,
That is,
that is,
that is a notice.
that is a, yes, Malak, that is a notice.
Okay.
That is a notice, Malak, given to the vehicle owner, and this, if the logical, Malak, the fine, the notice provides, Malak, that
Just a minute. This is 7-6-3.
60. Because in the first read petition, it was not allocated part of the read petition.
Page
Page
87.
87, 7 series.
21st of November 2025.
Yes.
What is this?
Malak, this is given to the owner, the bus owner. All the owners have been given, Malak. The notice for mandatory rerouting of your stage carrier permit number so and so for the vehicle bearing registration number so and so as per provision of section 72. We have said that with reference to the subject cited above and in compliance with RTA board resolution dated 13/10/2025 issued under the purview of section 72 of the Motor Vehicles Act so and so, I am directed to inform you that as part of the Green City Bus Route initiative to promote cleaner, safer and more community-friendly urban transportation, diesel fuel city buses will be phased out from the city bus route number 23 and route number 36 with effect from January 1st of January 2026. Accordingly, your aforementioned vehicle, which is currently plying on route number 23, shall mandatorily rerouted.
Required to be rerouted.
To be rerouted in any one of the following routes of your choice. As per the recommendation made in the joint inspection report submitted by the members of the District Road Safety Committee, then Malak, we have given these 10 routes. Available slots, Malak, because it is first come first basis. These are the routes, Malak. Then therefore, you are instructed to appear before the office of the undersigned on or before 22/11/2025. This is 1 month notice, along with the original stage carriage permit of your aforementioned vehicle and all related documents for mandatory route change, so that your vehicle could ply on one of the aforesaid routes of your choice with effect from 1/1/2026. This is given to all the vehicle owners who have not opted till then.
Yes.
So they have 10 options. They can very well go there if they have financial plans for them, they cannot change to CNG. Therefore, but my respectful submission is not that in the entire.
But the viability thing, Mr. Mahanta was arguing that it has been forced upon them. In the name of the policy, you have not only tinkered with their source of livelihood, but you have given an alternate route which are not viable. That is what has been submitted.
Now, logical see, 20 years before this position of the city and the present position of the city, the extension of the Gauhati city nowadays, these things are dynamic now. The things are going ahead. Now all things are going up to Mirja, Vijayanagar and in the North Gauhati block, everything is expanded. So these routes ultimately, if that be so, then all the buses, all the 400, 500, whatever the number is, all will come and they want to fly in these routes. Then in that case, nobody can take a decision because if a person claims a fundamental right that, no, I have my pass, I will fly here only. I'll not go anywhere because it.
No,
it
that
depends-
he's not arguing. That is not arguing. He says that I was given a permit for this route. That permit was given by following the due process of law. And because of a policy, that permit had to be uh, cancelled or prematurely.
It is modified. It is modified. Without, in fact, my lord, we have said that you continue here. Come with CNG or electric.
Mr. Mahanta, you did not challenge the changeover, the policy as such.
No, let the question of, there was no such policy. My case is this.
No, that will come back to you. But the entire decision to change over to E mode, that is not the subject matter of challenge.
No, yes. In the second petition, I brought in because first time it was not there. Then I challenged this when we got it. First petition, kindly see,
First, we have read the
Good.
prayers.
6117. Here,
5425, 5725,
এখন affidavit এর প্রয়োজন আছে?
impure notices.
ওখান নাকি? 6117 না? আচ্ছা। Here, Lordship will find
We have read the relief which was seeking in both the petitions.
yes.
That perhaps was left out.
My lord, what happened? The decisions, though taken, it must be implemented first.
No, that we have understood your
Yes,
case,
whenever,
that the decision has not been taken according to you in the manner prescribed,
yes.
but the decision as such to convert, is it the subject matter of challenge?
This is
Per se.
first we came because they wanted what? They wanted to
Green route or
green route. They declared it as a green route. Our case is that the 5/4/2025 RTA meeting resolution number 2.
Yes. 5/4/2025, we have seen that is a challenge in 6117.
Yes.
And the rates being high is one of the grievance.
No, here also it says designation of city bus route 23 and 36.
Yes.
Here we have challenged it that they do not have the power to designate it as such. And
No, that we have understood. The
subsequent,
jurisdiction part and the power part, but the decision as such per se, is it the subject matter of challenge?
kindly see.
The manner of taking the decision you have put to challenge.
Yes.
But the decision as such.
We have come before this court whenever we were affected by their immediate action. They may have decided anything, we are not party to all. In some 1 or 2 meetings, they invited us to participate because I cannot directly go there. And then we came to know. And when they issued certain concrete things, executed.
Can you show us from your your relief prayed in either of the petitions where you have put this to challenge? One we have re-verified. Mr. Nath has
Yes,
elaborated page 27 of 6117.
yes.
And we have also we're also examining page 44 of the other writ petition,
Yes.
44 onwards.
Quashing we have passed, I have asked for quashing the impugned resolution number 2. Here
Yes.
of 5/4/2025. Here it says.
5/4/2025 is the decision which have challenged in the earlier writ petitions. No
Yeah,
problem with that. No problem with that.
Yes.
5/4 we have seen.
Yes,
You have challenged the RTA meeting of 5/4.
2025.
Yeah, that you have done in the second writ also.
Yes. Now, thereafter, when they took this decision to oust us directly, then we came with the second writ petition. You see, kindly see that impugned resolution number 2.
These are all subsequent resolution. We have checked. These are all
Yes.
subsequent resolution.
Resolution number 57/2025.
There is
Impugned resolution dated 5/8/2025. We have challenged all these things.
these are all subsequent resolution. We are on the substantial part, whether the decision to convert per se is the challenge, subject matter of challenge.
No, decision to convert to
E mode or green mode.
that is, once they declare it as a designated route, they can take such a call. Our case is that
No,
they, without doing
procedural
this,
part we have understood,
they,
but
they should have noticed that you should be derouted because we have a permit, we are running there. Now, when they say
okay, yes,
that you
we
will
will
be
come
derouted,
back to you in your region. Yes, and
that's
complete
easy.
it.
Those notices at page 83 or 87, my friend has referred to. Only then, 87, those notices to us.
But I have taken your lordship to the notice, just to show that the alternative was given to them. And otherwise,
At 21/11/25.
10 options were given. And this is done as per resolution of 13/10/2025 at page 183. I was reading Roman 1. At page 183, kindly come to Roman 3.
As per resolution dated
13/10/2025. It starts at page 182.
of which rate?
Of the- of-
7263.
No, the 6117 of 2025. I'm reading the affidavit.
No, we had gone to 87 of 7263.
7 to 63 to show the notice.
Okay.
That
This
is
is
the-
at page what? 181.
We are on 182.
182
of the affidavit in opposition in the 6117.
611.
7 of 2025 declaration.
Okay.
In the affidavit, I'm reading the affidavit
Yes,
of opposition at
yes.
page 182. I have read the resolution number one of that meeting at page 183. And kindly come to in that particular page, kindly come to Roman 3, notice to individual owners. So decision was taken that upon receipt and approval of the feasibility report of the honorable chairman so and so, the DTO secretary may issue individual notices to those vehicle owners who have not rerouted their buses or failed to submit undertakings agreeing to reroute their buses from route number 23 and route number 36 as per section 72 of the MV Act and the rules framed thereunder. Accordingly, those notices were given. So decision was taken on 30th of October 2025. Page 182. Affidavit.
Yes.
So accordingly, notices were issued on 21st of November, giving them time till 21st of or 22nd of December, 1 month time. 1 month notice.
This is in accordance with 13/10/2025, wherein you had taken three major decisions. One is to convert to green, second is feasibility of other routes, and third is to issue notice. And pursuant to that, notices are issued on 21/11/2025, which is page 87 of 7263.
In the petition, the petitioners they referred to a decision of the honorable court earlier. At that point of time, finally the petition was withdrawn. But honorable court, while giving that liberty, it was given that notice has to be given, 1 month notice has to be given, and if you want to do something, you give them notice, then do. That 1 month notice has been. This is the complaints of the petition.
Where is it? Page?
In the petition, lordship is holding law.
We are holding 6112, 6117.
Yes, 106. Page 106 is the order starts.
106. Yes, 106.
Lot. The grievance lordship will find that para 3. para 3. Okay, in this writ petition, the petitioner has assailed a notice dated 28/2/2023, issued under the hand of the respondent number 3 in the matter of removal of permits of the city buses from their authorized routes. In the said notice, by enclosing a list of registration number of city buses, it has been ordered that those city buses have been removed from their authorized routes as per decision taken by the board meeting of the RTA, Kamrup, held on 20/12/2023. In the notice, reference has been made to another meeting held on so and so 13/12/2023, wherein indicating the presence of the representative of the petitioner association, it is mentioned that the representative of the petitioner association in the meeting has assured to render support to the decision to be taken by the RTA. By the said notice, the petitioner association has been requested to remove the city buses whose registration numbers are mentioned in the enclosed list from authorized routes from 1/1/2024. The notice was given on 28/12/2023, and from 1/1/2024, they were directed to stop. Then at para 7, page 108, Lordship has issued notice. And para 16, kindly come to 1111111.
What had happened to this order of interim order was passed on 7/2/24?
Page 117.
117.
117.
Withdrawn.
You know the withdraw.
Is the
Lordship.
was any elaborate order passed in the IA 1355 of 25? Don't think so.
But in fact, in that petition, the issue was 1355 order at 113, page 113.
No, nothing. Only to withdraw.
Only to withdraw. The issue in that petition was that they were not given 1 month notice. And on 2012-2013, they have taken the decision. From 1/1/2024, you have said us that you go to the other route. That was the ultimately issue in that case. No opportunity was given to them, nothing. So if Lordship kindly considers para 16 of the order by which notice was issued, that Lordship will find at page 111. May I read?
Just a minute.
Lordship.
Now this rate was dismissed on withdrawal without any liberty also.
Liberty was paid for, it was there.
Liberty was given.
Yes.
Liberty. 117.
Praying for
We filed an application. Once details were there, not recorded by the court. But nonetheless, it was written.
Page number 176 of writ petition 7263.
1355 was your IA civil for permitting to withdraw the petition.
Lordship,
Okay.
yes.
I've seen it.
117.
In the affidavit.
No, maybe writ petition.
Our officer goes.
Lordship has granted stay in that matter, and para 16 kindly see para 16
Of,
of the first order in the repetition while
Yes.
issuing notice,
yes.
para 100, page 111, para 16. Having found that,
Yes, yes.
having found that, before taking action by the impugn notice dated 28/12/23, which amounts to suspension of to the permits, no prior opportunities had been provided to the stage carriage permit holders of those 200 number of buses. From aforesaid, the same amounts to violation of principle of natural justice. In such view of the matter, this court is of the considered view that the petitioner has made out a case for interim relief in the form of suspension of the notice dated 28/12/2023. Accordingly, it is observed that till the returnable date, the operation of the notice dated 28/12/2023, whereby 200 numbers of city buses having valid permits have been withdrawn with effect from 1/1/2024 shall remain suspended. As a corollary, it is further observed that this interim order shall be in respect of those stage carriers permits which have validity period beyond today, that is 7/2/2024. It is however observed that pendency.
Mr. Dasgupta, you have been sitting since morning. Chance is very less. With the trend going on, chance is less. Which matter?
The number 30.
Is there any urgency? Urgency is there? Urgency is there or what?
It's only amendments.
IA.
Go in the IA by the first.
IA for?
Miller, only one prayer has to be incorporated, nothing more.
Prayer has to be incorporated. We'll allow the amendment.
That is a six must.
Lordship,
No, I discussed with you, Sigla.
notice may be issued.
Mr. Mohantab, just 1 minute. We can,
They are waiting.
yes.
My friend actually.
You can also take a break of 5 minutes.
Given number turn to?
39.
39.
Your Lordship,
You want to file objection or what? Have you filed objection?
Your Lordship, page.
No, understood.
It's come for the first. one.
Amendment of a incorporation of a prayer.
Yeah.
So
Prayer.
how will you prejudice?
Yeah,
How will you be prejudiced? What kind of prayer has to be incorporated?
Lordship, if kindly takes page 60.
Just a minute. Let us see the application.
Two-
Which part, Mr. Dasgupta?
2900.
No, which part you need to incorporate?
Last prayer, blood. Page 16.
page
That you may be allowed to amend it to insert in the prayer why the impugned communication dated so and so exhibited. You got to withdraw the benefits of the. We will incorporate this.
Yes.
You incorporation doesn't mean admitting this. It's only you giving us a scope to file your consolidated affidavit. Have you filed your affidavit?
No, Lordship, it has come for the first.
No,
one.
no, not here. In the
Main case we have.
you can file an additional affidavit.
Lordship, kindly may take page 16, Your Lordship.
16, yes.
Yes. Paragraph 9, Your Lordship.
Yes.
It is stated, though it is prayed at the prayer portion of point 3 to show cause as to why the respondent shall not be directed to take any action for filing writ petition, this and this. The official who communicated the issue withdrawal of benefits under fair wage policy has also not been impleaded as respondent. That impleadment, we have
Yes,
no.
no, only Mr. The order who passed this order, he has to be implemented.
Yes.
And this order is in the writ petition. This impugned order, this is in Annexer J, Annexer G.
19.3.
Yes.
19.3 was not specifically put to challenge.
Not currently.
We'll allow this. What is that? Third, Sri A. Dasgupta, learned senior counsel for the applicants.
If Randy, 10 days time just to seek the instruction. 10 days time.
Not in all cases, madam.
No, only this matter.
Not in all cases. We don't grant time in all cases. This is not a matter to be objected. It's only amending the prayer. Is it? Does it amount to allowing the prayer?
It's a prayer that prayer number 1, Your Lordship, it is.
We are not allowing the prayer. It will be a prayer in the writ petition. You will have all the rights to contest that. We have not said anything on merits. How can you preclude somebody from challenging something? Can you? It will lead to multiplicity of proceedings. That is not what we desire. Heard.
In this matter, Mr. DCK is addition.
Doesn't matter, madam.
Yes.
Have you said at the first go? that the senior is there. And is it a matter to be objected? Should know how to.
Actually, I had a discussion with him also.
No, we are not.
was
These
not
are
told
petty
me
matters.
that
These are
it be
petty
allowed.
matters, not to be adjourned. Heard Sri A. Gupta. Oh, what is the protocol?
Big petitionটা দিই। It's 576. 576.
Heard 3A Dasgupta Learned Senior Counsel assisted by
AR Das.
AR.
AR Das.
AR Das for the applicant's writ petition has also heard Miss Anne Bodloy for
For 1 and 2,
the ONGC.
1 and 2 in item number 39.
For the ONGC. Mr. Da-
Item 40, madam, this is a tag matter, I mean.
But IA has been filed in. Third. Oh, okay.
Item, file only in item.
That is it, okay. Then in 40, don't write, this is 39, okay. By the present application, comma, the applicants have prayed for an amendment in the writ petition to incorporate a prayer to put to challenge and a communication dated 19/3/2024, full stop.
That is Annexer F.
It is the contention of the applicants that the said communication has already been annexed to the writ petition
As
as annexure
F.
F.
Hmm.
Full stop. However, there was no specific mention in the prayer portion, full stop. It is further submitted that since the communication has been issued by the Executive Director, Chief Employees Relations, ONGC, comma, the said officer is thought to be impleaded as respondent number 4, full stop, para. Ms. Bodloy, the learned counsel for the respondent numbers 1 and 2, has however raised objection by stating that in the meantime, comma, affidavit in opposition has already been filed in the connected writ petition, full stop. Any other objection, madam? She has also submitted that since the matter has come up for the first time, comma, instructions may be allowed to be obtained. Para. After hearing the learned counsel for the parties, comma, this court is of the opinion that the present application seeking an amendment will not cause any prejudice to the respondents in defending the case, full stop. This court is also of the opinion that upon allowing the amendment, comma, the respondents would be given a fair opportunity to file an additional affidavit to raise additional affidavit after the amendment, full stop, para. In view of the above, comma, the instant IA stands allowed and the prayer as reflected prayer for inserting and the allowed permitting insertion of prayer number 4 in the writ petition as indicated in the IA, full stop. Further, comma, the Executive Director, Chief Employees Relations, comma, ONGC, as mentioned above, be impleaded, is allowed to be impleaded as respondent number 4, full stop. The learned counsel for the Ms. Sri Das.
Yeah.
Sri Das, the learned counsel assisting the learned senior counsel, is accordingly directed to file amended cost title. No, not amended, consolidated writ petition.
Not court title.
Consolidated writ petition.
Mhm.
Inserting the amendment as well as the respondent number
4.
4. 4 you will be taking a notice, madam? Same, your officer. Since the newly implemented respondent number 4 it would be represented by Ms. Bodloy, comma, no fresh notice is required to be issued. Para I stands disposed of. In the writ petition, you write, while an order passed today in IA number so and so, amendment of the writ petition is allowed in the manner indicated in the said order, full stop. Sri A. Dasgupta, learned senior counsel assisted by Sri so and so, is accordingly required to file consolidated writ petition, inserting the additional prayer and also the newly implemented respond number 4. Full stop. The newly implemented respond number 4 being represented by Miss Anne Bodloy, learned counsel appearing for the ONGC, may file. No, don't say. The newly implemented respond number 4 is already represented by Miss Anne Bodloy, learned counsel for the ONGC, full stop. The respondents would, however, be at liberty to file additional affidavit after. Huh?
If so required.
If so required. Okay.
I'm obliged.
Yes. Back to electric bus. Other matters will have dates. May not be possible. Mr. Sharma?
My lord, my item number 48, your lordship was pleased to fix it today.
Today will not be
Wednesday.
possible.
Next Tuesday will be fixed.
Next Tuesday.
Yes, ma'am. 41.
What is your matter, Mr. Talukdar?
MSc appeal.
MSc appeal.
2016 matters, my lord.
Oh, 16 matter. Next Tuesday.
You know, see, in item number 41 to 44, we have 5 objections, so 2 weeks time may be granted.
We like to file objection.
Yes, sir.
What, IA for?
I have for the stay vacating.
Yeah, for the applicant.
Yes.
Lekha, ito. Heard 3. J. Sharma, learned counsel for the applicant. Applicant or applicants?
Applicant.
1. Who has filed this application for modification of the interim order? Para. 3A Chetri, learned counsel for the opposite party or parties? One.
Parties.
More than one.
Yes.
Opposite parties, writ petitioners, praise for, and is granted 2 weeks time to file affidavit, to file objection. Full stop. Para. List on, we give a date.
Yes.
We have it on 11th. 11th? 11th September. Interim order passed earlier stands extended till the next date of listing.
Already.
Okay. I stands disposed of.
Already.
Lord's
Oh, no,
permission.
I am not saying. Okay, no, okay. File objection. Okay.
But with Lord's permission, item 49 to 55, there was some urgency, whether if it can be taken up on some date, on a fixed
Okay,
date.
Wednesday.
When is time date?
Etu date dilu na, etu I2. I2 kiti nek dilu 11th. Interim order stands extended till the next date of listing. Okay. Yes. Mr. Nath, complete it.
Lordship, kindly come to, Lordship, I was reading para 16 of the order.
Yes.
It starts at page 111 of the writ petition. Kindly come to para 112. The first part I have read. Shall I start from this?
112, yes.
Sir.
No, that you have said only on the consideration of violation of principle of natural justice, the interim order was passed. That you have clarified.
Last sentence.
Yes, yes.
It is however observed that pendency of the writ petition shall not be a bar for the state respondent to consider the modification of the permits of so and so buses after hearing the permit holders strictly in accordance with the provisions of law.
Oh. Yes.
But
Order to.
But that liberty was given only to that extent I have referred to. But If watching for a moment takes up 72, section 72 of the 88 Act.
72 of the MV Act. Yes,
72 Roman 22.
Yes.
72 to Roman 22. That the Regional Transport Authority may, after giving notice of not less than 1 month, vary the conditions of permit attached to the permit further conditions. So 1 month notice has been given now.
but he is saying that this is subject to that that part was, you must have followed that part, that this has to be read along with
72 1.
proviso.
Provided the conditions specified in persons to clause 1 shall not be varied as to alter the distance covered by the original book by more than 24 kilometers, and the three variations within such limit shall be made only after RTA is satisfied that such variation will serve the convenience of the public, and that it is not expedient to grant a separate permit in respect of the original route so as to vary.
No, later part you can, it's not right. First part, proviso, the first part of the proviso.
First part is
Provided that the conditions specified in pursuance of clause 1
1.
shall not be varied so as to alter the distance covered by the original route by more than 24 kilometers. So the alteration is what Mr. Senior Counsellor submitted is only with regard to the distance. You cannot change the route altogether. That is the submissions made.
But my humble submission is not, this one provides that the distance covered, if some modification is relating to distance, then it should not go beyond that particular limit,
24.
24. The second part is independent block. Ultimately, kindly see the entire provision of the 72 and the power given to the RTA is to regulate the transport. And the permit has to be the authority, after giving notice of not less than 1 month, they can modify the conditions in the park.
Let us read again the proviso.
Logic.
Provided
Provided that the conditions specified in persons of clause 1 shall not be varied so as to alter the distance covered by the original route by more than 24 kilometers. And
rest part not required. Rest part is not connected.
logic.
Shall not be varied so as to alter the distance covered by the original route by more than 20.
Finally, it is the convenience of the public.
But what is clause 1?
Clause 1 is very the condition of the permit.
No, clause 1 is not very.
Sorry.
Clause 1 is that the vehicle shall be used only in a specified area or on a specified route or routes.
Logic.
So in the context of that clause 1,
Logic.
this proviso is there.
Come on.
What would be the interpretation of this? What would be the meaning?
But finally, the proviso, if the entire proviso is read,
Please read. Yes.
kindly see,
Yes.
the provided that the conditions specified in pursuance of clause 1 shall not be varied so as to alter the distance covered by the original route by more than 24 kilometers, and any variation within such limit shall be made only after the RTA is satisfied that such variation will serve the convenience of the public, and that it is not expedient to grant a separate permit in respect of the original route so as to vary or any part thereof. What my respectful submission is, the 72 of the Act provides the power to the RTA to.
Mr. Nath, you are missing out something. Please read out carefully.
Lodge.
Provided that the conditions specified in pursuance to clause 1,
Lodge.
not the conditions in clause 1.
Lodge.
So when you giving the permit under clause 1, you can have some conditions.
Lodge.
It is only with regard to those conditions where you cannot make a variation. That is the only interpretation available.
Lodge.
Mr. Mohanto, you have to answer this. Have you read the language?
Yes,
Provided that the conditions specified in pursuance to clause 1.
yes.
Clause 1 as such does not have any condition. If while acting under clause 1, you can have some conditions. You can impose some conditions. It is those conditions which are being referred here.
It is as regard those conditions.
Those conditions.
Lodge. Lodge.
So ultimately, your thing may be a correct interpretation because clause 1 as such does not have any
Any
condition
condition.
that the
Clause 1 is-
vehicle shall be used only in a specified area
specified
or
area.
on a specified route. These
Lodge.
are only specification. Now, it says that conditions specified in pursuance to clause 1,
Lodge.
not in clause 1,
This-
pursuance to clause 1.
So the RTA has the power to specify the area or to specify the route.
And impose some condition, and
Condition.
those conditions
Condition of.
shall not be varied.
Lodge. Lodge. And,
Okay.
and not. Lodge.
If there is anything, you can let us know here. Just deliberation only brings out the correct interpretation. That is what we think.
Lodge.
Because use of the expression in pursuance of will not mean any, will cannot have any other meaning.
Lodge. That's.
My lord,
that's
while
I- I
granting a
accept.
permit
Yes.
under 1, 72(2)(1,
Yes.
they put certain conditions.
No, yes, it is those conditions which are being.
It's.
It
but
is not
only
one, it is not one as such.
No,
It is the conditions under 1.
Conditions pursuant to 1.
One.
Pursuant to 1.
Yes.
I stand corrected because the earlier by submission.
Yes, yes.
I missed this
One.
point, Lordship
Yes,
has
yes.
rightly pointed out. I am grateful.
Mm.
My lord, here kindly see, provided that the conditions specified in pursuance of clause 1.
Yes.
Clause 1 says that it should be road specific.
Specific, yes.
Road specific.
Yes.
Now, being so, having made it road specific, you may fix certain conditions.
Mm.
That
Yes.
these are the conditions you must follow.
Mm.
And in pursuance of those conditions, it says that shall not be varied
Yes.
so as to alter the distance covered by the original route by more than 24 kilometers.
Yes.
In those conditions, if they go for variation, the length can be shortened, but the route cannot be. That is the interpretation given by the apex court. The route cannot be changed altogether. Otherwise, the whole permit will be meaningless. If route goes, well, the permit goes. Conditions, they can vary. But route as such cannot be taken away because the whole clause will be over if route is changed. Conditions will not be relevant then in that case. Conditions are relevant only with respect to the route. If the route goes,
Yes.
what is the meaning of the conditions given in the permit? Therefore, it says, made it very clear, the distance, so far distance is concerned,
Yes.
you can shorten it. There can be
You are
variation.
referring to the SK Nurul case.
Yes,
No, I have a submission.
No. Just trying to
Lodge.
get everything clear.
Lodge. But on that decision, sir,
Just a minute.
to my understanding,
8 and 9. Clause what is prohibited by the provider to subclause 1. But this entire discussion was of 72-1.
72-1.
What, you're not on 72-2.
my lord,
This variation is not connected with 72-1.
72(1), my lord.
Yes, 1 was, there is a proviso to 72-1.
Yes,
Provided no such permit shall be granted in respect of any route or area not specified in the application.
yes,
It is only in regard to that proviso that the discussions in paragraph 8 of Nurul has been made.
Yes, yes. True, my lord.
Para 5-6.
Here,
Para 5-6 of the judgment.
Here, but then the language employed by the apex court is,
It is only on 72(1). Again, the second part. It will be a modification which is contemplated and provided for under subsection 1 of 72.
yes,
We are on the aspect of 72 to 22 proviso,
yes,
which only talks about clause 1 of 72(2).
72.2.
Yes.
That 72.2 here specific 72.2 is not mentioned or not interpreted.
Section 8 of that judgment.
Yeah. But then, my lord, kindly look, lordship will kindly look into, see, because here, when it talks about the conditions specified in pursuance of clause 1,
Yes.
then it means that the conditions which were put while granting the permit, making it road specific, then in those conditions, if variation cannot be made, except that if in case of the length of the route, you cannot change it beyond 24 kilometers. That means the route must remain the same. Conditions can be varied, which conditions you have put, and so far the length of the route is concerned, little variation is permitted, not beyond 24 kilometers. Because my response submission, to my understanding, if the route goes, then permit also goes. Because the permit is route specific only.
Yes, yes.
Therefore,
Consider.
route as such cannot be changed. Then permit goes as a whole. No question of maintaining or retaining those conditions, consequential conditions. Am I
Yes.
clear, my lord? I think in that sense, this is very clear. Provided that the conditions specified in pursuance of clause 1 shall not be varied so as to alter the distance covered by the original route. When the distance cannot be altered, the route must be same. The route cannot be changed.
But see the second part of
Yes.
the proviso.
And
There may be a difficulty for you.
my lord,
And any variation within such limit shall be made only after the RTA is satisfied that such variation will serve
the
the convenience of the public and that it is not expedient
to
to grant a separate permit in respect of the original route.
So
that means the route can be varied.
Route can be varied. That
So
is
as so varied in or any part thereof.
A separate permit in respect of the original route as so varied or any part thereof. My lord, my understanding is here, route remains the same. There can be variation so far the length is concerned. If
May not be.
If
what would be the meaning of the last line then?
Yes, then transport authority is satisfied that such variation will serve the convenience of the public. My lord, convenience of the public. That
public then, and that is not not expedient to grant a separate permit in respect of the original route.
Yes, my lord, what
so
happened?
varied.
My lord, that is why I refer to this case, Nurul Amin. Here, court has explained by citing examples. Route is said, suppose as I said.
No, that is in context of 72.
No, true, my lord, let
us not confuse.
My lord, no, my lord.
The illustrations
if
is under 72(1) proviso.
My lord, if 72(1), 22(1) B, here, if we see that also, my lord, to my understanding, a route originally permitted, say, from Gauhati to Mirza. Now, they want that no, and Mirza to Gauhati. Now, authority found that the bus, earlier it happened, my lord, bus cannot be allowed to come up to Moscow. It must terminate at Jalukbari, suppose. And accordingly, they may vary the conditions, they may vary the length of the route. And if they feel that for that no separate permit is required to be issued, the same route permit will be there, but the route will be automatically shortened. Length of the shortened, and there will be no necessity to issue a separate permit for that. It will amount to variation, but whole route will not be taken away.
Yes.
That is my small submission, because 272(2)(1) says the vehicle shall be used only in a specified area or the route. Therefore, I say, my lord, that it may be in all probability my small submission, it still says the interpretation should be that the route itself cannot be taken away. Because if it is so, then no question of issuing a separate permit goes altogether. Nothing remains.
Yes,
Obliged.
Mr. Complete, Mr. Nath.
Yes. My respectful submission is that under 222, the action has been taken by the RTA. There is, RTA has the jurisdiction, and so far, the decision, Lordship, I have said, para 5, 6 and 8 of the West Bengal decision, it is specifically under 72(1). Lordship, I am relying on two decisions. As regards the violation of fundamental right, on the point of fundamental right violation, kindly take up for
Citation, please.
Lordship. This is 1952 2 SCC 590.
Sugar Sugar is on policy.
No, that is on policy.
Sugar Sugar is on policy.
TB.
Yes. TB Ibrahim, okay.
TB.
The straight jacket.
Lordship.
Straight jacket, unruly horse. What is the?
No. TB Ibrahim was on even fundamental right. I am relying on para 16.
Okay. 1952.
52.
1952. 2 SCC 590.
Yes, 590.
TB Ibrahim.
By judge bench.
Constitution bench.
Lordship.
Ibrahim. Paragraph?
Para 16.
16.
16 and 17. Lordship.
Okay.
There, the issue was this bus stand was shifted to some other place. The petitioner said that he has a fundamental right to run this, to stop that bus, to stop that bus at that particular area, because otherwise it will affect his business, the right violence. The Honorable Court, while taking up that matter, kindly come to para 16. The next contention was that the order is repugnant to the Article 19(1)(g) of the Constitution, according to which all citizens must have the right to practice any profession or to carry any occupation, trade or business. It cannot be denied that the appellant has not been prohibited from carrying on business or running a bus stand. What has been prohibited is that the bus stand existing on the particular site being unsuitable. From the point of view of public convenience, it cannot be used for picking up or setting down passengers from the stand for outstation journeys, but there is certainly no prohibition for the bus stand being used otherwise for carrying passengers from the stand into the town and vice versa. The restriction placed upon the use of the bus stand for the purpose of picking up or setting down passengers to outward journeys cannot be considered to be an unreasonable restriction. It may be that the appellant, by reason of the shifting of the bus stand, has been deprived of income he used to enjoy when the bus stand was used for outward journey from Tanjore. But that can be no ground for the contention that there has been an infringement of any fundamental right within the meaning under Article 19(1)(g) of the Constitution. There is no fundamental right in a citizen to carry on business wherever he chooses, and his right must be subject to any reasonable restriction imposed by the executive authority in the interest of public convenience. The restriction may have the effect of eliminating the use to which the stand has been put hitherto, but the restriction cannot be regarded as being unreasonable if the authority imposing such restriction had power to do so. Whether the abolition of the stand was conducive to public convenience or not, as a matter of entirety for the transport authority to judge, and it is not open to the court to substitute its own decision. So my respectful submission is, Similarly, in this case also, in our case also, petitioner has said that the decision has not affected their livelihood. So the fundamental right under Article 19 and 14 and 19 has been violated. There is no fundamental right, they cannot claim that we have to run the bus here only. If we go out, then our right gets violated, and it impacts their business. But reasonable restrictions we can. Two things, Lordship, I have already submitted, it is at the cost of repetition, I'm indicating. We have given them two alternatives. In fact, we have given them option to come up with electrical CNG vehicle, or if they don't, they can go to 10 routes. Notice clearly said, even go to that route. We are not affecting their livelihood. So there is no fundamental right. They cannot claim fundamental right for claiming that they have to be allowed to fly the bus in route number 23 and 26 only. The next decision I have placed, it is on Lordship has already indicated, it is on policy decision, para 18. This is 2001 CSSC 635. Relevant is para 18. This is relating to trade of liquor in Delhi. Some policy has been taken by the government that was given.
Limited scope of challenging unless it is grossly arbitrary or
So
competence. So, yeah.
just permit me to read
Yes.
the paragraph 18. The challenge does, in effect, is to the executive policy regulating trade in liquor in Delhi. It is well settled that the courts, in exercise of their power of judicial review, do not ordinarily interfere with the policy decisions of the executive unless the policy can be faulted on the ground of nullifying, unreasonableness, arbitrariness, or unfairness, etc. In the arbitrariness, irrationality, perversity, and nullifying will render the policy unconstitutional. However, if the policy cannot be faulted on these grounds, the mere fact that it would hurt business interest of a party does not justify invalidating the policy. That is my submission. There is no malafide, there is no arbitrariness, irrationality. It is pursuant to a decision of the authority that we are phase-wise. We are doing it phase-wise for last 1 year, and ultimately the honorable court has observed that by giving them, we can modify the conditions. So the ground taken by them that the fundamental right has been violated, and they were informed, they have the knowledge, and in fact, while in this case, in the petition, when the order was issued, but the interim order was reviewed, the petitioner went to appeal. In that also, the honorable court has disposed of the appeal on 19/12/2025. I'm just placing the order, because the time limit was from 1st of January. They said that on 19/12/2025, first page Lordship will find the association has put the order dated 17/12/25 passed by the London signatures in WPC number 16117 of 2025. Just two observations. The last page number 4 kindly come along. Second paragraph. Internal page 4. At top right hand corner also will find the page.
Page
Internal page 4.
4, yes.
4. Second paragraph.
Yes, we
find from the record that the notification in question doesn't exclude the members of the appellate association from flying their buses on the aforesaid green routes, subject to converting their vehicles into electric and CNG operated vehicles. We also find no merit in the contention of the appellant that such decision has been taken only for the purpose of monopolizing the flying of the state operated buses in the above green routes. The notification do not spell out that the said green routes would be limited only for the state owned buses, but for all CNG buses. The decision of the RT may not amount to implementation of a new scheme, but only varying the conditions of the permit, where the requirement of section 98(1) and 101 of the MV Act would not be applicable. This I have shown Malad, because the provisions of 103 has been argued. My respectful submission is Malad, that is under chapter 6 of the Act.
What is the second, before withdrawal, what is this observation? We keep open such question for the present?
Yes, Malad, Malad, finally.
No, please read that.
We keep open such question for the present as Mr. So-and-so, London Senior Counsel for the Appellant Association, seeks to withdraw their appeal in order to test his case before the London Single Judge with the liberty to him to press for seeking some financial benefit with respect to payment of the dues.
What is this?
The second prayer. That is what, Malad, for 6 months they are paying more.
Okay, that said, you have said that you are already
It is under consideration.
consideration. You are addressing it.
Yes, it is under consideration. Should not be succeeded before the London Single. So, but they said that for 5 years you are taking 3,000 rupees, for 6 months you are taking 2,000 rupees. It is
Okay.
in the higher side. Therefore, in my respectful submission, Malad, on all these 3 counts, Malad, this is a policy decision taken by the government. No interference of the Honorable Court is in this matter is to call for. Petitioners were given ample opportunity, Malad. They were hard notice the opportunity natural justice has been followed, and they were given 2 options. Either if you want to remain here, you convert it to electric and CNG, or you go to the 10 routes given to you on first come first serve. Most of them, majority of them have gone. 158, 50 remains, 100 already gone. And there is no violation of any fundamental right. In this case, although they have urged that their fundamental right to run the buses, we are not touching their livelihood. So, having the decision has been taken by an authority under the Act, having jurisdiction, there is no impropriety in the decision. Therefore, in my respectful submission, this is a case.
Okay,
having no merit.
okay.
And only that, as regard 103, 103, section 103.
Yes.
That has been argued.
Yes.
My humble submission is, that is under chapter 3, that starts under from section 97. It is special provisions relating to state transport undertakings. 98, 103 has no application in this case. Kindly see the definition, what is state transport undertaking? Definition,
Yes.
in the Act, kindly come to 242.
Yes.
State transport undertaking
Yes.
means any undertaking providing road transport service where such undertaking is carried on by central government or state government, road transport corporation established under section 3 of the Road Transport Corporation Act 1950, any municipality or corporation or company owned or controlled by the central government or one or more state governments or by the central government or one or more.
Definition 2.
Definition 242. So this is a provision relating to special provision relating to state transport undertakings. Here, there is no such. We are simply, the decision is simply that these particular 2 routes, 23, route number 23 and route number 36 will be green. No diesel operated diesel buses will fly on that. That is the decision. Doctor.
Yes. Milord, firstly,
Just 5 minutes, Mr.
Well,
Monta.
yes.
5 minutes.
Milord, I will not repeat the things which
Okay.
are already placed. My response submission, Lordship has seen, I have argued again 72. Milord, I still rely on this apex court decision, Nurul Amin. 72 as a whole, the court has discussed. There, it indicates that you cannot, in the name of modification, obliterate the entire route itself.
That you have
Yeah,
conveyed.
that
Yes.
power is not there. That power is not there.
Okay.
Now, if this is not there, they are taking shelter under 72. If this power is not there, then to act beyond that, the way they have acted, they must be able to show that there are some other provisions which we can apply, which they have not been able to show. Their basic thing is 72. Now, my response submission is to here, my lordship can see, we have an existing permit.
That you have said.
Yes.
And it is for a
existing
particular
permit.
tenure.
Yes, tenure. Particular tenure prevailing for a particular tenure when these permits are there. To nullify it altogether, to obliterate it, they will have to have some procedure. What are those procedures? The procedure as prescribed under chapter 5. Under those, they are required to issue a notice, give us 1 month's time, then only on those, only on those MB Act. Certain, yes, sorry. But here lordship will find only on those grounds they can modify or cancel the permit.
Yes.
Otherwise not. They have not invoked this. They have not invoked it. And therefore, question of acting under those provisions of chapter 5 also doesn't arise, because if they say that the transport authority, state transport authority or the regional transport authority is the authority constituted by the statutory body as constituted by the state government. Therefore, under section 68 rule subsection 3, they are to follow only execute the directions, policies of the government.
That you have said.
Yes, and
that will consider.
And a government to formulate routes for applying stage carriages. It is for the government. Now, government has already said that these two routes are only for the stage carriages, buses. Now, they want to show that we designate it as green route, and therefore we want you to be mandatorily rerouted, whether there is power. These powers under section 72 doesn't give. These powers are not available under section 72 in my respectful submission to the bodies. And therefore, there is no government direction also. No policy is formulated, no direction is given. Therefore, under what authority they are acting? Question is first jurisdiction. If they have no jurisdiction to act, section 72 doesn't authorize them to do this and cancel the permits having tenure up to 28-29, then the action cannot survive. And the next question is raised that my livelihood, fundamental right. My lord, my fundamental right is to get fair treatment. My fundamental right to get protection under the laws. Law provides certain rules. These are my guarantees that if certain action which is prejudicial to my interest is to be undertaken, it must follow the procedure as prescribed. That's why Supreme Court, Apex Court has repeatedly said, this court has been following, that if a certain procedure is prescribed, you follow it, else you cannot do anything. That is one part. And the policy, as such, there is no policy. What is that policy? Lordship asked me that question, whether I have challenged that green route concept. Yes, I said yes. Because the very first action which they took, what they said, that you are to be mandatorily rerouted. That's the notice given to us. This is a notice not asking us to give our opinion as regards cancellation of our permit. This is not that notice. That your notice on your permit on such and such grounds are liable to be cancelled. And so, what is your opinion thereon? It is no such notice has been given. 1 month's notice? No, there was no such 1 month notice. Notice is only to reroute us compulsorily.
What, according to you, should have been the notice?
Notice if they want to give us notice to cancel. As
No,
I
no, not
submitted,
cancelled, rerouting. What notice?
reroute it, they cannot.
No, no, according to what notice is to be given?
No, my response submission is to change the route or to cancel my permit. To change the route, first they will have to cancel my permit. And those conditions on which permit can be cancelled is specified under section 86. 86. Only this provision they will have to invoke. 86. Cancellation and suspension of permits. My learned
But
friend is also submitting.
is it an action for cancellation?
Sorry?
Is it an action of cancellation?
No, they have not done it. Therefore, my question is, I'm raising the question that is, when I have an existing permit, you have allowed me to run my bus on these routes. Now, if you want that, no, we will not allow you, they will have to first cancel my permit. And for that, they have 86. Section 86, they will have to act upon. Can they suddenly stop? Well, I don't find any provision. And that is only provision is 103. That is chapter 6. Chapter 6, only when a scheme is floated.
The chapter 6, he says, is pointed out rightly that it pertains to the state transport undertaking,
Transport
which has been
undertaking.
defined under 242.
Here, transport undertaking, even Lordship has seen. If the transport undertaking is given that, ASTC is given that, then ASTC is not doing it. It is done by.
Don't you think that will be far-fetched?
No.
Something is not given, it's not a negative equality.
No.
That
What I'm saying
entire
is-
chapter 6 pertains to state transport undertaking, which has been defined under 242.
This is
If it is 242,
only here, state transport undertakings
yes, undertakings is
for
defined
their
in
benefit.
section 2, subsection 42.
2 of section 42.
Yes. You do not come under that. That
Well,
chapter is a special chapter.
Yes, it is specific chapter.
No, it is a special chapter for state
My contention is
transport undertakings.
transport undertaking to facilitate the transport undertaking to take certain action. Here.
Yes.
Here also they want to show because it is given to the STC to facilitate ASTC to employ its buses.
Correct.
They are making this. But in fact, ASTC is not involved directly. It is the two private individuals, two companies are involved here, private companies. So therefore, here also they wanted, if they wanted that the ASTC should be facilitated to run buses only in these two routes, they can make provision under section 6, under chapter 6. Under chapter 6, they have the power to cancel the existing permits and ask for rerouting, that you may go to some other route. We make it available only for state undertakings.
Is that the import?
Yes, kindly see. The provisions of this chapter and the rules and orders made thereunder shall have effect, notwithstanding anything inconsistent therewith contained in chapter 5. I'm reading at section 98.
Yes.
In other law funny timing.
This is a non-obstante clause only for the purpose of state transport undertakings.
Yes, my lord.
Not for others. This
Well,
cannot be applied to others.
My lord, no. Chapter 5 is otherwise applicable to all vehicles.
Yes, this
Now,
98 says that this chapter will override chapter 5.
Yes.
So why is this chapter? Because it's a special provision relating to state undertakings.
For them it is made. For them. That is why I'm saying, my lord.
Yes.
Now they say
Yes.
that we want that these buses should be plied by ASTC. ASTC has been given because the cabinet decision also spoke about that first they should stop plying these buses, diesel fuel buses or petrol fuel buses. Only ASTC shall stop doing it and they will bring in
Okay.
e-buses. That was. That was, this is for them. And in that case, if you make this special provision for them, declare, that can be done only by declaring certain routes reserved or a scheme only for them. In that case, yes. And then in that case, they can also cancel the existing permits.
Under
103.
103.
403. And they can shorten.
We'll consider. We'll consider.
Those are not there. Otherwise, they will have to act under 86.
Okay,
Separate
we'll
fact.
consider. We'll consider.
Therefore, my
Well,
submission is.
We'll request both the parties to give not maximum 3-page written submission, only the grounds. Facts we have noted.
Yes, yes.
Because this court, next 2 weeks, this court is not there. We are reserving the judgment.
Yes.
But we'll give the mail ID of our secretary. You can mail it to us.
Well, great.
Today itself, Harry. Amar Biner mail ID to. Biner mail ID লিখি পেলাই তেখেতসকলক দি দিবা. Okay, but give it within 2 days or 3 days maximum.
Next week?
Next, latest by next Monday.
Yes.
Okay.
Next Monday.
We'll carry the file. Okay.
So I will conclude saying that my challenge, whenever the action is initiated, which spiritually affects me, I am to challenge that. And there itself they have said that this is a green route initiative scheme under this, and therefore we are issuing this for mandatorily derouting you or rerouting you somewhere. So I challenge this. So it includes, challenge includes everything, their entire decision to go for.
Okay. Heard Sri K.K. Mohantalanat, Senior Counsel, assisted by Ms. N. Begum. Also heard Sri D. Nath, Learned Senior Advocate, and Ms. M.D. Bora. You have not said anything, Madam Bora. You wanted to say something, we did not allow you to. He's already said. M.D. Bora, Learned Standing Counsel, Transport Department. Here, hearing is concluded. Full stop. The parties, the Learned Counsel for the parties is at liberty to file, to submit written arguments, precise in a precise manner, precise written arguments, not more than 3 pages. We have everything. Okay, and there is no requirement to again cite the case clause. You can just give the
Citation.
only the citation. We have already recorded. Okay, don't put elaboration is not at all required. Okay. By Monday, please mail it to our secretary.
I'm grateful, my lord. At least the matter has been concluded today.
No, we were conscious of this matter.
Exactly, my lord.
Because 2-3 occasions we were not in a position to. Okay.
That's given the whole day at least.
But we could not take up other matters today. At least 1-2 matters are.
It happens, my lord.
Your lordship.
Yes.
For item 41 to 44, it was fixed on 11th of September. Due to some personal difficulty, can it be taken on 17th of September?
Who has fixed it? Item number who asil? No, kun asil? Who was the council? Oh. We can have it some other day. Well, you are with Mr. J. Sharma?
For PD Nair.
PD Nair, but you have to take the, is Mr. Sharma, his convenience? You give a date of your convenience, we can change it.
Highly okay.
Okay, contact Mr. Sharma and come back to. Okay.
Highly okay.